for a hearing held to investigate allegations of massive fraud, drug money laundering, and support of terrorists by the Bank of Credit and Commerce International, or BCCI. The Senate Foreign Relations Subcommittee on Terrorism, Narcotics, and International Operations has held several hearings this week to investigate BCCI. On Tuesday, a former BCCI official testified about the secret ownership of First American Bankshares of Washington, D.C., and insisted that the former chairman and president of First American were aware that BCCI owned their bank. Today, the subcommittee took testimony from the former chairman of First American, Clifford, and the former president, Robert Altman. We now turn to the hearing chaired by Senator John Kerry of Massachusetts.
The hearing will come to order, please. Morning. Today, the Subcommittee on Terrorism, Narcotics, and International Operations is going to hear testimony from Mr. Clark Clifford and Mr. Robert Altman, the former chairman and president of First American Bankshares, and formerly attorneys for the Bank of Credit and Commerce International. Their testimony constitutes the 8th day of hearings of this subcommittee into the BCCI affair. And obviously, their role is a critical one in terms of trying to understand precisely what has taken place in the course of the last 12 years or so. Their actions have already become the subject of widespread investigation of federal and local law enforcement, as well as federal regulators and other committees of the United States Congress, as well as this committee. Both gentlemen have previously testified before the House Banking Committee concerning some of the matters under the jurisdiction of this committee. Our intent today is not to try to repeat every single part of the testimony before the House or all of the questions raised there, though inevitably there will be some repetition. But we hope to try to broaden and to deepen the inquiry and to cover a fair amount of ground that may not have previously been reviewed in public. I would like to emphasize on behalf of this committee, and I have tried to do this throughout the process, that neither the chairman nor the committee, nor I think members of the committee, have drawn conclusions or made statements that are conclusory, with the exception perhaps of one item, and that was the question of production of documents before the committee. But as to who did what, when, or how, or who knew what, when, or how, I must tell you, I don't think we know enough yet. And that is precisely the purpose of this hearing. I will say that I was somewhat surprised, even dumbfounded on occasion, to listen to my colleagues in the House, many of whom I thought issued a verdict before they had heard any of the evidence. I want to emphasize also that I don't view this forum as a perfect evidence-gathering forum. It is complicated. The inquiry does not allow us the kind of time, nor does the nature of the legislative and congressional process allow us the kind of inquiry that really is necessary, I think, ultimately in allowing people to draw sort of the ultimate conclusions here, using the words guilt and innocence to the degree that they enter into this. What we are trying to do here is draw conclusions based on facts that we can ascertain, and to ask some tough questions. And I think the committee is not going to pretend that there aren't tough questions there. I think both of you have acknowledged that, and you understand that, and you have stated that you are well prepared to answer those questions and to come before us voluntarily, without subpoena, as you did before the House, in an effort to do that. And we respect that and we appreciate that. There are many questions, obviously. How did a drug-corrupted foreign bank manage to pull off whatever it did pull off? How many people did they take in as victims along the way? Why did BCCI want First American? What warning signs were present from early moments that might have drawn greater attention to BCCI? And were they ignored by anybody? Did BCCI and the Middle East frontmen who worked with BCCI have any foreign policy agenda or any political agenda in purchasing a bank in Washington? Did the U.S. government have any political or policy agenda itself, or was it carrying out some sort of covert or subvert effort with individuals? What were the responsibilities of those who worked for this bank, ranging from attorneys to accountants to officers, as they learned of facts that suggested that something was wrong? What were the responsibilities of accountants and lawyers to this committee and to others once a probe began and once there was evidence of at least some people's wrongdoing? In previous days of hearings, witnesses involved with BCCI, such as Mr. Masihur Rahman, who was the chief financial officer for BCCI, and Mr. Abdur Sakhia, the former head of BCCI for the United States, both characterized themselves as victims, deceived by others rather than as partners in the deception. In previous testimony, Mr. Clifford and Mr. Altman have similarly described themselves in forceful terms as victims of the criminality of others. As I said earlier, our job here is to try to open a window on this affair, and I will insist that the committee do so in a way that is not recriminatory or in some way berating or ugly. I don't think that's the way we want to work, and that's not the way that we do work. Let it be said, because I think it was said in the House, and I think all of us feel it, that it is not a comfortable or happy occasion to have this kind of investigation. And I know that neither of the witnesses, who have had distinguished careers and who have been upstanding members of this community and who have made major contributions, that neither of them are happy to be here, obviously, or comfortable with this situation. But we are here, we have responsibilities, and the purpose of this is to ask the tough questions and to try to shed light on this affair. So I appreciate your willingness to be here, gentlemen. I know you've been through more depositions and meetings and presentations on this in the past month than you care to recite, and I hope today's hearing can be an important contribution to the process of truth-finding. I would like to just make one comment, and that is that I picked up today's paper after hearing yesterday of this event, and I must say it upsets me, it concerns me, and that is the question of a 33-year-old White House aide who has now left the White House without prior legal experience of a significant kind, suddenly finding himself hired as a former aide to John Sununu to represent one of the principal litigants in this affair, Mr. Kamal Adam. And apparently he has gotten a fairly significant contract to the tune of some $600,000 for 2 years to assist Mr. Adam in his efforts to deal with this matter. I personally, just from my own legal experience, must ask what someone without prior criminal experience or major experience who is prohibited from making contacts because of his recent employment offers for that kind of money. And I think it is that kind of link that raises so many questions in people's minds about Washington, about how this process works. And it just casts a cloak of suspicion over all of us, over the entire process. And I think the average American is sitting there saying, what the hell is going on in the nation's capital with all this money passing back and forth? I think it may raise more questions, as much of this does, than it gives answers, but so be it. Senator Brown.
Thank you, Mr. Chairman. Mr. Chairman, thanks to your leadership, the web of secrecy that surrounded BCCI is slowly being removed. We're beginning to see a pattern of an international effort which has involved many notable, well thought of people in this country as well as people around the world. Today we have witnesses that I think can provide some crucial information to us in this effort. Witnesses who have not only been shareholders but have been counsels to BCCI and indeed officers of First American. So I think the testimony today will bring to light and bring out in the open a pattern of activity by BCCI, which will help us understand not only the method of operation, but how indeed they were able to achieve the remarkable results that BCCI did in accumulating a worldwide banking network. So I think today's testimony will be crucial for us not only in understanding the method of operation for BCCI, but I hope it will be helpful in understanding how we can formulate statutes that will protect this nation in the future from an international banking organization that is bent on financing and promoting criminal activities.
Thank you very much, Senator Brown. Gentlemen, by prior agreement with your counsel, the committee we normally have 10-minute openings, but I understand that a significant amount of information has appeared publicly in recent weeks since your last testimony, and you understandably have a sense that there is much you would like to answer to. So by prior agreement, we are affording you 45 minutes to be divided as you wish, and we look forward to hearing your opening statement. I presume, Mr. Clifford, that you'll lead off. Am I wrong?
Oh, that's correct, Senator.
Thank you. Can you pull the microphone a little bit closer? I think you'll find it. Yeah, thank you. Oh, let me ask. I think photographers, we had agreed if you could move to the side so that it will not be distracting to the witness during his opening testimony. Beg your pardon? Oh, I'm sorry. Indeed, forgetting my duty. Could you rise so that I swear you in, please? Thank you. Would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. I listened with care, Senator, to your opening comments, and I thank you for them. We welcome the opportunity to be here today and to present our side of the story. Over the course of the past 9 months, the other side of the story in great detail has been presented day after day after day. Our side has pretty well gotten lost in the shuffle. I had wished at time that we might have a newspaper so that we could publish what we know about the matter, but we don't happen to have that privilege, so we have to depend upon opportunities of this kind to get our story before the authorities and hopefully before the American people. From the day the Fed started their inquiry, we have cooperated with the government. We got in touch with the Fed at once after they began in January with their uncovering of the facts. We appeared for long depositions under oath before federal counsel. Then next we testified at length before the United States grand jury here. In all the years that I've practiced law, that's the first time I'd ever had that privilege. And Then we went to New York, and again were questioned in long days of grueling interrogation by the staff of Mr. Morgenthau. Then, perhaps one of our next opportunities was to appear before the members of the House Banking Committee. And during the course of that day's hearing, I would estimate that we would ask questions by each of the 50 members of that committee. We welcome this opportunity here today. This gives us a chance for you to know our involvement and to ask us all of the questions that you wish. The reason that we have chosen to follow the policy of using every opportunity to present our case is, to state it simply, our consciences are clear. It is very clear to me, I go back over the details of our involvement, we have not violated any law, we have not been guilty of any impropriety, and so we make ourselves available at every opportunity so that others may know as clearly as we of our participation. As you might suppose, I've given a great deal of thought this last 9 months as to how I could permit myself to become involved in this controversy with a group of persons from far-off lands. And in the process of my statement today and in answering questions, I would hope that that might reveal itself as to how I became acquainted with a situation which has been a new experience for me after all these years of the practice. If you are to understand what took place from our standpoint, then I must tell you the story. I will do it briefly, but it's a very personal story. And I think that's one of the reasons that our participation has not been perhaps understood clearly, is that it has been such a personal experience for me. Here is quickly the story. I met Mr. Abedi first in December of 1977. I've been practicing law in Washington since I left the Truman administration in 1950. He was brought in by a former client of ours, Bert Lance. It was to be merely a social visit, and it was. He said that Mr. Abedi was a foreign banker. He had come to know him, that they had become friends, and he had a high regard for Mr. Abedi, and he wanted me to meet him. I found Mr. Abedi to be a man of considerable charm, man of slight build and stature, very attractive manner, spoke perfect English, nothing of the promoter type about the man at all. One of the main subjects we discussed in that brief social meeting was the aim that he had for his bank of providing the third world with banking services which they had not ever had before, and that had helped so in retarding the progress of third world countries. I found him to be pleasant and a man of importance. Thereafter, I'd hear from time to time that little reports would sift in that Mr. Abedi and BCCI were in the process of acquiring stock in a company called Financial General Bankshares. That's a bank holding company centered in Washington. I had not heard of them before, but we were told later by another principal character in our story, Sheikh Kamal Adham, that he had first heard about Financial General from the public relations man in the Saudi Arabian embassy. There'd been a number of articles talking about Financial General and how it was breaking up into cliques of shareholders and how it was going through a very difficult time. The man in the Saudi Arabian embassy looked into it in some more detail, concluded that it might be an attractive acquisition. Apparently that was one of his functions in the Saudi Arabian embassy, to pass information of that kind back to Saudi Arabia. Kamal Adham was a recognized, highly regarded businessman in Saudi Arabia. Kamal Adham then said, after getting that information, he passed it on to Mr. Abedi. Mr. Abedi served as investment advisor to Kamal Adham and to a number of important and very wealthy Arabs. Fact is, they had produced the funds that permitted Mr. Abedi to start his bank. So he had a very close relationship with them and maintained that during the course of the years. When Financial General learned that some Arabs were acquiring stock in Financial General Bankshares, they became concerned about it. They looked into it, and at that time they found that 4 Arabs, good morning, Senator, had purchased each about 4.5% of the stock, staying under the 5% limit, but it gave them a holding among the 4 of them of around 18%. The owners of Financial General went to the authorities and SEC and said, we want you to look into this. These Arabs may constitute a group, and perhaps they should have filed. Also, Financial General hired a very efficient and effective New York law firm who brought a suit at once in the district court in Washington to prevent a possible takeover of their company by these Arab individuals. It was at that time that we were retained, our law firm, Clifford and Mr, retained by Mr. Abedi, by the 4 Arabs, by BCCI, by Mr. Lance, anybody who was sued at that time, all came in together and retained our law firm. We went through 3.5 years of the most strenuous litigation in that case. We also brought in an expert firm in the takeover field, Wachtell Lipton of New York. During that 3.5 years, I got to know Mr. Abedi well, and I got to know Kamal Adham well. A litigation of that kind is like being in a war. There's a series of battles. Some of them you win, some of them you lose. And you get to see men under stress and under the different contingencies that follow that kind of litigation. I must say my regard for Mr. Abedi increased during that period of time. He evidenced a sense of fairness, he evidenced a wiseness about banking matters and all that were really quite impressive. During that time, gradually, fortune began to favor our side, and we got stronger and the other side weakened. And after a while, I received a phone call from one of the principal figures in Financial General, man you all may have known, Armand Hammer. Lived in California. I'd known him from the Johnson administration. He said, Clark, why don't we declare an armistice? He said, this war goes on interminably, and I'll come on and we'll sit down and talk this matter out. And he did, and brought some directors over. In a day and a half, we sat in the office, talked it out from different arrangements, and then we agreed upon a disposition of it. We agreed upon a very fair price, and our investors and clients purchased 100% of the stock of Financial General and paid cash for it. Then we entered into a lengthy period in going through the regulatory process. The purchase of the bank holding company had to be approved by the Fed and by the regulatory agency in the states in which Financial General operated. We went through that regulatory procedure. The Fed here in town felt that the importance of the case warranted a hearing. So 4 of our clients came over from the Middle East and testified. Representatives of the various states were there, representatives of the Comptroller General. It was a good, long hearing that aired every detail of the matter. As we were proceeding on in that regard, I became conscious of the fact that Kamal Adam, whom we saw a great deal of, although he lived in Saudi Arabia, he spent a great deal of time in London. And we had developed the process of going to London at rather regular intervals during the litigation, maybe every 3 or 4 months, something of that kind, keeping them very well informed. Decisions had to be made and so forth. We continued on with that because they indicated that they wanted Mr. Altman and me to continue to occupy an important place in the operation of Financial General. Finally, it came to a climax. And at a meeting in London with Kamal Adam and Mr. Abedi, they said they had discussed the matter with the investors, that's what we called the shareholders, and they wanted me to become chairman of the board. And they said why. They'd gotten to know us. They'd come to have implicit confidence in us. They were a great many thousands of miles away from this property that they owned, and they would feel comfortable if I would take over that position. I asked a number of questions. Would I be at the beck and call of the investors? By that time, instead of 4, they were 14. And they said, not at all. I said, will some investor call and say he wants us to make a loan to the ABC company? Said, not at all. This is nothing more than a simple financial investment on their part. I said, how do we get in touch with these 14 investors who really become our clients as owners? They said, we've talked that out with them, and Mr. Abedi would be designated as the contact between us and the investors, along with Kamal Adam. Kamal Adam would refer to himself as the informal chairman of the investors. That made sense to us. It would certainly make it more convenient to keep in touch with the investors instead of having to do it with all of them. I agreed to do it. Now, why did I agree to do it? I was 75 at the time. There was nothing particularly interesting going on in the firm at the time, and this was a challenge to me. This was a company that had a real potential that was not being realized. I'd done work for banks over the years, off and on, and it was a challenge to me. It was another mountain to climb, and after satisfying myself that the arrangement was understood, I agreed to take it. Only on the distinct and unequivocal understanding that as chairman, I would have total responsibility and I would have total authority. I'd learned that lesson in government. The road to disaster is to take a job in which you have a high degree of responsibility, but you don't have adequate or commensurate authority to go with it. They said that was agreeable to them. The deal was made. I came back and started at once getting together the board of directors. I assembled a group of the most distinguished men that I could find. One of them was former Senator Stuart Symington, who'd served with great distinction for 24 years in the Senate, now retired. He was my oldest, maybe my best friend. I invited him to come in. He was delighted to do so. He was made vice chairman. We agreed upon compensation with the board. I said that until we had proved ourselves, that I wished that to be very modest. And we wouldn't bother with that. We'd get to that when the right time came. And my salary was set at $50,000 a year, and Symington's was set at $20,000 a year. We brought in other top-flight men, General Gavin, who'd had a wonderful war record, a former ambassador to France, and at the time serving as president of Arthur D. Little investment advisory firm. We brought in Elwood Quesada, who together with David Rockefeller had made a great success of the L'Enfant Plaza development. He'd held 3 different positions in the Eisenhower administration. Other men of that caliber. I learned that here's a great asset in the United States that really was not being taken advantage of. Here were men who'd had very successful careers, had gotten into their 70s, didn't have very much to do, and this really was a great and exciting opportunity to them. And we went to work. I'm happy to say that our effort was an unqualified success. When we took over the company, its assets were $2.2 billion. By the end of 1988, for instance, the assets had grown to $11.5 billion. The deposits rose from under $2 billion to approximately $10 billion. Very significant, as showing the confidence of the public in the bank. Earnings, we doubled in the first 4 years, and then in the next 2 years, we doubled the earnings again. We were really beginning to roll. Now, this was no ivory tower experience for us. This was a hands-on occupation. I took it as my first obligation. They then owned 12 small banks. I went to every bank. I got to know the boards and the officers, key employees. We made an analysis of each bank. We had an audit made of each bank. Some of them were undercapitalized. And then we began to plan about strengthening these banks. We brought in new personnel. The fact is that over the years we've brought in a new CEO for every one of our banks. A number of those banks we consolidated. Others we sold off. They didn't fit our plan. We bought some excellent acquisitions, 33 branches of Bankers Trust in New York that gave us a splendid deposit base there. We brought a number of branches in Virginia when two firms merged and had to divest themselves. But interestingly enough, most of the growth came from within. Now, after 4 years of this, then we got to a point where we knew we were over the hump. And I thought the time had come for Mr. Altman and me to participate in the results of this very determined effort that we had made that was proving to be so successful. I took it up with the directors of the top holding company, CCAH. They said that they thought that was a great idea. We took it up with Abadi and Kamal Adam, and they said we could participate easily in the next stock offering to shareholders. If all of the stock was not subscribed to, why then, under the bylaws, we could subscribe to stock. We did that in 1986 and became shareholders. I'm watching my time, Mr. Chairman, so some parts of it I must move over quickly. I wish now to turn to the results of our efforts. In an effort to give the committee a quick sketch of the manner in which we conducted the banks over a period of 9 years. Here were certain standards that we set, and here is the result. 1, there were no financial improprieties. 2, no fraudulent lending practices. 3, no account manipulations. 4, no money laundering. 5, no improper payments to BCCI. 6, no lavish executive perquisites. 7, no lack of regulatory supervision. We maintained the closest relationship with the Fed, and it was a most pleasant relationship. 8, in the 9 years, no U.S. taxpayer bailout. No bank had to be taken over. And 9th, but not last by any manner of means, no shareholder of First American has ever lost 1 penny. Have we been deceived by what we've learned later? If all that we read about this poisonous, constant stream of misconduct, if that is a true statement of what this bank did, then we have been grossly deceived. We never saw that. We never sensed that. I don't suppose it's much comfort to us, but during this 9 years that we did not know what was going on, the fact is that we learned from reports, neither did the Bank of England, who had the right to examine them regular intervals. The Bank of England apparently was deceived. Most curious, we read, their own auditors, Price Waterhouse, apparently were received. I read someplace, authoritatively, that for the years 87, 88, and 89, Price Waterhouse had given to BCCI that very intriguing British expression, the accounts are fair and accurate. A former Prime Minister of Great Britain served BCCI for a substantial period of time. Apparently, they had developed a relationship with former President Jimmy Carter. How could it have been done? To me, the best explanation that was offered by somebody who'd been into it very deeply was there were really two banks. One was the outer bank, and that's the one that we saw, and that's the one that we dealt with, and that's the one in whom we developed confidence through these 9 years. The other was an inside bank that was unknown. We never saw it. We never sensed it. I've thought about it so many times. Did we miss any signs? Should we have sensed it? I would give anything if we had. And it would save us really from this dreadful, painful year that we've been through. But as I near the end of my time, I want to say, when it all comes down, and I keep reading that Clifford knew, somebody says, and they say, well, how do you know he knew? Well, we don't know it, but he just had to know. Witness recently said, he just couldn't have run First American for 9 years and not know. I've heard it over and over again. I speak up, all of you with your experience know how difficult it is to disprove a negative. Somebody says you knew, how do you prove that you didn't know? We've done our best in that regard, but it is a difficult process. But here, I think, is the final point. Apparently, that BCCI corrupted everything it touched. That's what we read about. It corrupted banks, it corrupted governments we read. Thousands of people, depositors have lost. And we begin to get some notion from the constant outpouring of news of the manner in which it was able to corrupt so many different areas in the world. Question is, did it corrupt First American? That's really of great moment to us and of great moment, of course, to this committee that has made such a deep and exhaustive investigation into it. Did it corrupt First American? Not in any way. Do I ask you to take my word for that? I do. My word has been important here for a great many years in Washington, and I ask you to take it, because I know that they did not corrupt First American in any way. But I also, in addition to that, ask you to take the word of the Federal Reserve. You've heard Virgil Mattingly, the General Counsel, testify. He has said they discovered through the years no financial improprieties existing within First American. William Taylor, whom we regard as the Chief Enforcement Officer, testified at no time were they ever able to find any improper payment to BCCI or any improper financial relationship with BCCI. Recently, Mr. Robert P. Black, the president of the Federal Reserve Bank of Richmond, which has jurisdiction over First American and all the banks in this area, testified. I think I can end on no better note than just some selected sentences from Mr. Black's testimony when he testified under oath before the House. Each of these is significant. Each of these is significant to the committee. First quote, "The examination and inspection record between 1982 and late 1988 is clear. Neither the reports of our First American inspections nor any of the reports of examination prepared by other federal and state regulators contained comments or criticisms regarding involvement of, influenced by, or improper payments to BCCI. The second, when new disclosures involving BCCI occurred in 1991, an in-depth inspection of the First American organization was initiated. A total of 52 examiners from all 12 Federal Reserve districts with an average experience level of 8 years expended in excess of 7 man-years on this examination. And what did they find? I'm getting near the end. Quote, "And in delving into these records, we have found no evidence of influence and control or any indications that the banks were involved in any attempt on the part of covert owners to influence others. This investigation is ongoing, but preliminary findings have disclosed no abuse of the banks or significant exposure on the part of First American to BCCI." And then this is his final sentence. "Simply put, no connection between the bank's lending practices and their unauthorized ownership by BCCI has been uncovered." Under the arrangement that we've had with the chairman, I would take the majority of the time. Mr. Altman will present some portions of it that will fill out the mosaic, and he will limit himself to 10 minutes.
Thank you very much, Mr. Clifford. Mr. Altman.
Mr. Chairman, Senator Brown, members of the committee. Senator Simon and Senator Jeffords, good morning. I'm pleased to appear here this morning to assist the committee in this inquiry into the matter involving BCCI and First American. I am particularly appreciative of the chairman's reports at the outset of the hearing this morning regarding the balanced and reserved approach that this committee is adopting in this inquiry. And after offering these brief remarks, I look forward to presenting factual information in response to the questions that you have. I also hope that I would have the opportunity during the course of the day to correct some misinformation and some unfounded speculation which has been introduced into the record of these proceedings. Many people wonder how Mr. Clifford and I came to find ourselves in the midst of this controversy, and we hope to be able to shed some light on that question today. I think perhaps we can begin to examine that question by looking at the historical context of this case. There is an unfortunate tendency to view the events of the past through the distorting prism of sensational reports about BCCI that appear today. And to understand our dealings with BCCI, one must evaluate past events and our conduct in view of the knowledge and circumstances of BCCI that were then prevailing. As Mr. Clifford has described, our law firm began representing BCCI in 1978 At that time, I was a young lawyer in the firm. Our firm was actually quite selective in terms of the clients that we would agree to represent. And BCCI appeared to me to be an appropriate, even an attractive client for our firm. In 1978 and thereafter through the 1980s, BCCI appeared to be a successful, growing international bank. It was managed by professional, conservative bankers from Pakistan after Pakistan nationalized the banking industry. It was a company that we understood to be owned by some of the wealthiest people in the world. These were respected businessmen and leading political figures from the Middle East. It was a company that was regulated by the Luxembourg Monetary Institute and by the Bank of England in London, where BCCI had its world headquarters. The Bank of America owned a 30% interest in BCCI and participated in BCCI's management through representation on its board. And Bank of America was, of course, at that time the largest, and some would say the most respected bank in the United States at that time. We also understood that BCCI enjoyed important banking relationships with a number of major U.S. banks. These would include Security Pacific, First Chicago, American Express, Bank of New York, and of course Bank of America. And these highly reputable financial institutions in the United States also extended very large credit lines to BCCI. And throughout this period, throughout the decade of the 1980s, BCCI expanded its operations to more than 70 countries around the world. And in each instance, BCCI was able to obtain the licenses and approvals from the governmental authorities where it opened new banking operations. And to us, this signified BCCI's respectability and its acceptance worldwide. During the 1980s, BCCI also had known close relationships with leading world figures, people of unquestioned integrity, such as former President Carter and Prime Minister Callahan. BCCI is now portrayed in the media as an evil, corrupt organization. But I can say to you, our impression throughout the period we were representing BCCI was distinctly different. And I think that our impression of BCCI was accurately described recently by a man named John Hyman, who was former controller of the currency. He was former New York State Superintendent of Banks, and he wrote in the Wall Street Journal recently, I quote, "When I look back at its origins, I am struck by how respectable BCCI appeared then. Among other things, Bank of America was a major shareholder. Regulators in many nations, including Britain, opened their doors to what looked like a uniquely dynamic, well-backed third world bank." We had an equally favorable impression of the Middle Eastern investors who we also represented in connection with the acquisition of First American. These investors appeared to be reputable people of prestige and standing. Included in the group were the ruling family of Abu Dhabi and persons and entities associated with them. There were also involved in this group rulers from two of the other emirates in the United Arab Emirates. There were leading businessmen from the Middle East, such as a Mr. Foulage, who came from one of the leading families in Kuwait, former chairman of Kuwait Airways. Mr. Clifford mentioned Kamal Adam. He was a leading businessman from Saudi Arabia and enjoyed a first-rate reputation. And we have attached to our prepared statement that has been submitted to the committee some of the letters of reference that were submitted on behalf of these people, letters from some of the largest international companies and banks with which they dealt. We, in short, were pleased to represent these people. Now, attention has been devoted to representations that Mr. Clifford and I made to bank regulators in connection with the acquisition of First American. The fact is, it's not much mentioned, but there were 3 prominent law firms, all of us working closely together, all of us dealing directly with the clients. We all believed the information that we were presenting to regulators was accurate. And here we had unusual confidence in the information being presented because there were independent investigations of the proposed owners of First American by governmental authorities, investigations in which we did not participate. And the extent of those investigations was wide-ranging, and indeed, in light of the high-profile nature of this acquisition, it may well have been unprecedented. The Federal Reserve, in its testimony recently, has detailed the extent of those investigations. They were also the subject of hearings back in 1982. I will quote a couple of sentences from the hearing record. This was before Mr. Rosenthal's committee, testimony by Mr. Wallach, then member of the Federal Reserve Board. Question, Mr. Rosenthal. Mr. Wallach, can you tell us just a little bit how you checked to verify the backgrounds, the character, the integrity, the financial resources of the individuals? Mr. Wallach. The board worked very hard at this because, as my testimony says, this is a crucial matter. We used all the resources of the U.S. government, not only those of the Federal Reserve Board, and we developed information from a very broad informational source. We also, of course, obtained bank statements. We obtained financial statements of the individuals, and these were certified. So we did what I think is humanly possible to develop detailed information on these individuals. This investigation of the representations that were being made by these Middle Eastern investors has also been described in a letter that was written by the banking superintendent of New York State, in a letter that was submitted to Mr. Rosenthal. Again, I think a couple of sentences will give you the feel of it. He writes, after detailing the extensive nature of the investigation that they conducted, he says, all the information we received indicated that the investors were prestigious and reputable people. None of the regulatory agencies involved found anything derogatory about any of the investors, nor did the former top management of Financial General, who fought the takeover for almost 3 years. And he says our investigation was thorough and explored all available sources of information. It thus may be ironic that we had available to us in this transaction much more information than a lawyer normally has in a commercial transaction. Here we had sworn testimony from the key individuals. We had extensive background information. We had certified financial statements, bank references, personal business references. And then we had these extensive investigations and cross-checks by the United States government and by the state regulatory authorities. And all of the information that was gathered supported the representations that were being made. Let me conclude. We do not know what the truth is as to the allegations that have been leveled regarding certain of the First American shareholders serving as nominees for BCCI. The ownership issue is very confused. It's in dispute. Documents from BCCI which relate to this issue are suspect, according to Price Waterhouse, BCCI's auditors. From our standpoint, we never had any reason to distinguish between shareholders or to assume that some of the shareholders were legitimate and other shareholders were nominees. All of them appeared to be of the same category. Now, I think the committee will understand that no corporate management can know what a shareholder does with his stock after it is purchased. However, during the initial regulatory proceedings, we made commitments to regulators that First American would be operated honestly and properly under the control of Mr. Clifford and the Board of Directors. And whatever the facts are that are developed relating to the ultimate ownership of the stock of First American, I state to this committee without equivocation that we kept that fundamental promise to regulators. Thank you.
Thank you very much, Mr. Altman. Senator Jeffords has joined us. I don't know, Senator, if you have any opening comment.
I
or
have
not.
just a brief opening statement, Mr. Chairman, that I'd like to make a part of the record. I do have one question I would like to ask, if I could do that at this time. I have to leave to go to the markup of higher education.
That's fine. Sure. Go ahead.
Mr. Clifford, you have given us a very excellent statement on your position of what happened, and you are a very impressive gentleman. I note that you indicated that a number of people, as well as yourself, seem to have been deceived here, including the Bank of England. Mr. Altman mentioned the Bank of America, Price Waterhouse. All apparently were deceived by the activities that went on. In my mind, the purpose of this committee is to try to see what we can do to prevent such activities from occurring in the future, so that individuals or banks will not be deceived. It would certainly be very helpful to me if you, Mr. Altman, could let us know as to what kind of national or international structure or organization or regulation needs to be set up to prevent the occurrence of such events in the future.
I have read the pending legislation, Senator, S-1019, and I think it is excellent. I have also read a written memorandum by Virgil Mattingly, the General Counsel of the Fed, in which he comments on the legislation and indicates the portions of it that he considers to be so favorable from their standpoint. I was especially struck by a comment by Mr. Mattingly that he says that the Fed is considering the possibility of setting up what he calls a special investigative unit to investigate situations brought about by the experience with BCCI, so that people would not be misled, as you have suggested, so that there would be a form of international cooperation between the nations of the world, so that there must be certain basic information that we must receive in this country before we permitted a foreign bank to do business. I commend the legislation. I particularly recommend the approach of Mr. Mattingly, and I venture to say I deeply regret, Senator, that that wasn't the law when we became involved here. It would have saved us the most painful period of our lives.
Mr. Altman, do you have a comment?
I would supplement what Mr. Clifford says by observing that there are now reports, and we don't know the accuracy of them, that indicate that some of the branches of the federal government had information about BCCI that, for whatever reason, was not disseminated to other branches of the government, such as the Federal Reserve. And I think it might be a profitable exercise if there could be some attention given for mechanisms being set up so that when this kind of information comes to the attention of the authorities, it would be shared in a meaningful way with regulators and others who need to have it in order to perform their jobs and discharge their responsibilities. Again, it would have been very important to us, would have saved us a great deal if this kind of information could have been brought to our attention years ago.
Thank you, Mr. Chairman. I want to again commend you for your work in this area, and it's been a tremendous contribution to our nation.
Thank you very much, Senator Jeffords. Appreciate it. Thank you. Gentlemen, let me try now to begin a process of inquiry that I hope will put in front of you some of the doubts and sort of questions that people have as they look at the panoply of documents and assertions that have come forward. And I do so understanding that the record may obviously not be complete. We don't have all the documents. So you may have a document that suddenly appears and it says, aha, this is indicative of this, and there are 20 documents that indicate something else. And that is the question. Are there documents that indicate something else, and where are we here? There are a number of areas that I want to try to compartmentalize if I can, and we'll try to divide it up as we go along here. But one of the benefits will be we're not squeezed into sort of a 5-minute craziness here, and I think we can have a dialogue, hopefully. One of the things that troubles a lot of people as they look at this case, and there are many things that trouble us, and I think you know that, is this question of what you should have known or what you knew in the early stage. Now, Mr. Clifford, in your testimony, you essentially spoke as the chairman of the bank, and you spoke from the bank perspective. But you also wore other hats, and that's part of the complication here. The hat you wore as an attorney for BCCI, the hat you wore as the attorney for the bank that you were president of. And I'm not sure that you really spoke to us today from either of those vantage points, in a sense, though they are always confused and there's a mutuality. The question initially arises about the due diligence of the effort to learn about Mr. Abedi and the bank itself. And I believe that you have said previously that you talked to government personnel and made some kind of inquiry of, or some, you read an article in The Economist or something. Is that the extent of the inquiry into who these people were and what the nature of BCCI was back in during the initial takeover of Financial General Bankshares? Either gentleman who wants to answer it.
I'll start and we'll see if Mr. Altman has anything to add. You do refer to an article in The Economist, a highly reputable British publication, which had an extremely commendatory article about Mr. Abedi and BCCI. We also had the advantage of being able to talk to Bank of America. Bank of America was in with BCCI from the very beginning. It was organized in 1972. Bank of America was anxious to have a presence in the Middle East. It's very difficult to break in alone, and here was an operation which already had established contacts in the Middle East. So Bank of America came in from the very beginning and took a 30% interest in BCCI. They had, by the time they got to us in, let's see, 78, why, they'd been in the picture for 6 years. Their opinion of BCCI was a commendatory one. They had felt that their operation was a success, and I believe the reason that over a period of time they withdrew from the relationship was they did not need BCCI anymore. They established their own contacts by that time over the 6 years in the Middle East.
But didn't they have some problems with BCCI? Didn't Bank of America come to have some problems which actually came out in the course of the depositions regarding the takeover?
It is my understanding of that, Senator, that some questions were raised by Financial General at the time about First American's attitude, about Bank of America's attitude, and Bank of America answered those questions publicly with 2 public releases in which they stated that they had not had any difficulty with their experience with BCCI.
If I might just supplement that point, Mr. Chairman, I have here a press release from Bank of America. It's dated January 30, 1978. This is around the time that our representation commenced. And Bank of America was responding, well, I'll just give you a couple of quotes.
What was the date again on that?
January 30, 1978. I'd be glad to make it a part of the record. Newspaper articles have appeared recently suggesting that Bank of America is contemplating divesting its shareholding in BCCI. These reports have appeared following a recent reduction in Bank of America's holding in BCCI following a rights issue in which Bank of America did not participate. Bank of America is currently increasing its direct presence in the Middle East, and to have increased its capital commitment in a bank in which Bank of America had less than a majority holding or management control would be inconsistent with current Bank of America strategy. They go on to say Bank of America intends to retain a shareholding in BCCI for the foreseeable future, and the close cooperation that has developed between the two banks will be maintained, and they acknowledge that over the next several years they'll be selling their stake. They also issued a press release in September 1978 in response to that matter that you have referenced relating to the litigation, in which they felt it necessary to correct misunderstandings or inaccurate reports that had appeared in the newspaper about their attitude concerning BCCI. I would also offer that press release for the record.
Well, without objection, those will be made part of the record. What is the gist of that release?
Well, I will quote you again a couple of relevant sentences. Bank of America feels that in order to dispel any misunderstanding, it is necessary to address the Financial Times report which appeared in yesterday's edition of the newspaper. The specific points referred to in that article, attributed to Mr. Douglas Krause, a lawyer acting for Financial General Bankshares, appear to be taken from Bank of America credit review files. They describe the files and say that these are analytical, conservative, and closely controlled. It is Bank of America's present opinion that BCCI's loan reserve has been established in accordance with prudent risk management practices. Bank of America has maintained representation on the board of BCCI since the inception of its relationship. Then it goes on, it refers back to the earlier press release. Thursday's report suggests that the matters contained in Mr. Krause's statements contributed to the Bank of America's decision to reduce and eventually sell its BCCI shareholdings. As Bank of America has heretofore publicly announced, its reasons for that action are related solely to changes in market conditions, particularly in the Middle East, which make it appropriate for both institutions, the bank and BCCI, to discontinue the relationship. And I would also note, although I am reluctant to cite news articles in terms of accuracy, but I would also note that Time magazine ran an article on October 7th, 1991, in which they indicated that Bank of America throughout the 80s continued to have a very close relationship with BCCI, handling, according to this article, $1.3 billion a day of BCCI money.
No, that's accurate. And I think that one of the things that has intrigued people is the degree to which Bank of America may, in fact, have uncovered some problems and pulled back and then kind of slossed it over, and then indeed have competed, had competed as intensely as every other bank in the country did for the cash transactions. And there is obviously a significant flow of money from BCCI through Bank of America. So what I'm getting at is that there are many who said, well, they kind of washed their hands of some of the problems at the time, but were not willing to wash their hands of the profits at the time. And so they continued to flow. Now that's outside of your scope, but that is the picture that I think many have drawn from that. I'm not referencing the news articles themselves, but in the documents that were filed in the course of that takeover, Bank of America documents themselves asserted that BCCI or its subsidiaries or affiliates had made substantial loans to 3 or 4 of the Middle Eastern defendants in that suit. These are the people you were representing. Among them was Mr. Foulage. And there was an assertion that he had received a $5 million loan from a BCCI subsidiary in order to purchase his shares of Financial General Bankshares. Now, that assertion was made in 1978 and was part of the suit in which you were involved as attorneys. Evidence now documents that not only did he receive $5 million in loans, but Price Waterhouse shows that by 1986 he had $61 million, and by 1989 he had $113 million. So in fact, the very assertion that was made in your suit in which you were involved in 1978 is now proven to be the very case not only with him but with others. And so the flag is sort of waved saying, you know, shouldn't that have set off some kind of inquiry since you were involved in that suit? And there were other evidences of the Bank of England refusing to grant a full banking license. The bank had been the longest delayed bank in England to receive a full license, and it did not receive the full license because there were concerns about the rate of growth, the manner in which it was growing, its sources, and the nature of its investors. None of that came to your attention, I take it.
No, Senator. Some of this did come to our attention, but I'd like to see if I couldn't clarify it for the record. First, you referenced the loan to Mr. Foulage. There was a loan to Mr. Foulage. The loan was made by an affiliate or subsidiary of BCCI in Kuwait. I think it's called KIFCO. And that loan, we knew about at the time. It was disclosed to the Federal Reserve at the time. He testified about that loan at some length in deposition testimony, so this was no secret. And generally, it was well known that these shareholders had extensive banking relationships with BCCI. That was also known. In fact, most of them, I suppose, own stock in BCCI, or at least certain of them own stock in BCCI. So the relationship with BCCI, and in particular the loan to Mr. Foulage, was a fact that we knew at the time. I would only suggest that there be some caution exercised in reaching conclusions about the extent of Mr. Foulage's loans today, because we have seen reports, again, I don't know if they are accurate, that one of our other original shareholders, the ruler of Dubai, was reported to have $121 million in loans. It was on the front page of the Wall Street Journal and reported widely. And subsequently, he issued a statement, and it may even have been retracted by Price Waterhouse. He issued a statement that he had not borrowed any of that money from BCCI. So there's a great deal of question about the records of BCCI. Perhaps Mr. Foulage does have those large borrowings. I don't know what the answer is, and I don't know if he does what they would relate to. But the original borrowings from BCCI by Mr. Foulage were disclosed to the regulatory authorities and didn't seem to be a particularly controversial item.
Well, that raises another set of questions, which I was going to get into later, but not inappropriate to ask it now. I mean, throughout this process, it appears as though Price Waterhouse gets failing grades. I mean, you're just asserting that you have to be cautious because you don't know if Price Waterhouse's certified figures are in fact accurate. Is that correct?
That is correct, and I believe it is Price Waterhouse itself which has said that they have based those on records, and now they question the validity of, or authenticity of the records. So,
and indeed, there's a pattern, it seems to me, through this of Price Waterhouse's various entities having provided information, as Mr. Sakia said, that was either negligent to the nth degree or conceivably purposefully altered, and we don't know the answer to that. But that a lot of what has happened here was based on certifications made by Price Waterhouse that are clearly now way off base. And you would accept that?
I do not know whether Pricewaterhouse was negligent because I'm not familiar with what happened in their audits, what they were told, and what their requirements are that they're supposed to follow in the certifying statements, but it would certainly raise serious questions that they have certified financial statements year after year, and now there is a report that all of those statements are, in fact, woefully erroneous.
Were you aware of the relationship with Pricewaterhouse, Cayman Islands, and BCCI?
Are you talking about the recently reported loan?
The loan of $600,000?
The first I heard about it was as a result of this committee's efforts.
Is that an appropriate banking practice for a bank to be lending significant sums to its auditing entity?
I would say when I read it, it struck me as unusual. I don't know if it is done. I don't know what the practice is, but I think that it seemed to be curious.
The reason I thought it was unusual, Senator, is that I never heard it happening before, ever.
Thank you. Let me ask you now, in the early inquiry you made, there was a very fine article on you, Mr. Altman, that appeared in the business section of the Washington Post. And in it, you were quoted as saying, with respect to your early inquiry, that you checked with some of the most, this is a quote, and again, I can't attest to the accuracy, but it checked with some of the most senior government officials to find out whether this would be in conflict with U.S. policy or whether it would be contrary to the economic interests of the United States, which was a sensitive subject in 1978 with oil supplies in the Middle East. But, quote, Altman's and Clifford's contacts gave them a green light. Quote, we were not only advised that it would not be inconsistent with U.S. interests, but we were encouraged to take this on as being quite valuable to the United States, were we able to do it. Can you share with the committee who gave you that advice and who you checked with as senior government officials?
Perhaps I did it to some extent. It's 13 years ago. I knew people in the State Department because they were there and I had worked with them. And I checked in the State Department. I have a recollection of checking in the Commerce Department. And from one source that I checked, go to the cabinet members, these would be staff people, but at one source that I checked, they indicated that the United States was sending at the time $70 to $80 billion a year for the purchase of crude from the Middle East. And as far as our government was concerned, it would be their preference that as much of that money flow back to the United States as possible. Did us no good if it went to West Germany or Switzerland or Great Britain. So that there was no objection leveled at the time to effort by this group of Middle Easterners to acquire an American bank.
Well, excuse me, Mr. Altman, did you want to add? Or?
I do recall a conversation we had with Arthur Burns, also of the Federal Reserve. He was not then the chairman of the Federal Reserve, who expressed a similar opinion. And I also recall that Senator Symington at the time had some conversation with government officials, and he was very much taken with this notion of recycling petrodollars as a result of his discussions.
You don't consider staff to be senior government officials, I would assume, with all apologies to staff behind me.
I do, Mr. Chairman. I don't know about that.
Boy, you are a sick fan. What can I say? I shouldn't have my back turned to them now. I'm in trouble.
I feel comfortable. I don't.
Do you recall beyond that, did you check with the CIA at all?
I did not.
Was there any run through Justice Department?
No, and I think the reason that I didn't was because information had come as we were dealing, my recollection is with the Fed, that the Fed in its investigation was checking the CIA and checking the Justice Department and checking other departments of government.
Yeah, we did hear that in connection with the acquisition proceedings, that the Fed had talked to some of these government agencies, but we weren't privy to that information.
The reason I ask that is in the House, Mr. Clifford, I believe you said that I learned from others that our intelligence operations had a very high opinion of him, referring to Kamal Adham. They felt he had cooperated exceedingly well with the United States. And I wondered where this feedback from intelligence on Kamal Adham came from.
I do not have a specific memory of it.
You remember they signed off, though, on Kamal Adham?
I know that the Fed signed off on Kamal Adham and accepted him as a legitimate and well-regarded purchaser of First American. I know that.
There has been a recent newspaper report that I have seen that a man by the name of, I believe it's Raymond Close, a former CIA man stationed in Saudi Arabia, had spoken to the press in a very commendatory way about Kamal Adham, and that was a general sense that we had of him when we were dealing with him.
Well,
I don't know Mr. Close, and I've never talked to him, but I've seen the reports.
you never met Mr. Close?
No, sir.
Did either of you ever know him?
I did not.
Did you know of him back in 1978?
No, sir.
I did not.
But your comments then to the House seem to indicate some contact with the Intelligence Committee. Are you saying that with the intelligence community, are you saying that the information did not come from the intelligence community regarding Kamal Adham?
I cannot recall where it came from. I have many conversations with individuals, and I'd had some background in the intelligence field, and it may have come from those contacts that they had regard for him.
Well, maybe I'll come back to that later. Let me turn now to an issue that is another one of those issues. I mean, I don't think this question of how much you might have known then or not is a turning point or a critical component of this. I think it's one of the things that obviously has flagged a lot of people, because there were entities, regulatory entities as well as others, who were saying we're concerned that this bank seems to have a penchant to find nominees, and that it kind of grew very rapidly and shakily. But let us assume that you went through that process, that you had a green light, that everything seemed like go, this seemed like a good opportunity and a challenge as you've described it. So we go to another level here, which is the question of what was the standard, the expectation by which this relationship was supposed to be carried out. That standard, it appears, was set out by the Fed and others in discussions with you, and I would refer you to the documents now. I believe it is, I don't have the numbering the same way. It's the document, the Muckenfuss letter, the controller of the currency, document number 10 in your document book. And document number 10 is a letter to the Board of Governors of the Federal Reserve from the controller of the currency, senior deputy controller of the currency, Mr. Muckenfuss. And in this letter, on page 2, paragraph, second paragraph in number 2, highlighted here, it says the following: members of the proposed investors group for Credit and Commerce American Holdings, NV, Credit and Commerce American Investment, BV, also hold an interest in BCCI. It has now been represented to us, and this is the operative and I think critical language, it has now been represented to us that BCCI will have no involvement with the management and other affairs of Financial General, nor will BCCI be involved in the financing arrangements, if any are required, regarding this proposal. This commitment is critical both now and in the future, since such a relationship with another financial institution would be a significant factor in appraising this application. This is especially important in light of the overlapping ownership which will exist between Credit and Commerce American Holdings, Credit and Commerce American Investment, and BCCI. Moreover, any enhanced direct or indirect affiliation or relationship between BCCI and Financial General would take on even greater significance in light of the fact that BCCI is not subject to regulation and supervision on a consolidated basis by a single bank supervisory authority. Now, that it is your understanding, I gather from testimony previously, represented the state of the takeover. Is that accurate?
I think the correct answer would be, first, Senator, we are very familiar with that language. We've been over it on a number of occasions, and the background of the whole affair is that if you look at that language in the light of what was known to the government at the time, both to the Comptroller General's office and to the Fed, it was known that there'd been a definite agreement upon our part in three areas. One, BCCI would not acquire any stock in First American at the time of the tender offer. Two, that they would not in any way finance the purchase of the stock of First American. And three, that they would have no control over the operation of First American. We presented that, we emphasized it. At the same time, at each stage, we informed the regulatory authorities that there were two areas in which we would continue to have a relationship with BCCI. One is they would be the communications link with the investors, and second, they would continue to be investment advisors. And that was known from the beginning by the government regulatory authorities.
A couple of additional comments, if I might, Mr. Chairman. One, I want to go back to your introductory comments before you got into the specifics of the letter in which you indicated whether there were flags there. It is certainly true that we were aware of regulatory issues that arose about BCCI's status, but I think it is very important to put on the record that at no time did we get any information or get any sense that the regulatory issues related to the lawful operation of BCCI, the ethical practices of BCCI, these were regulatory issues, not issues relating to whether BCCI was, I think you used the word, a shady operation. That was not at all the sense that we got from any regulatory authority during this period.
Well, isn't it fair, though, Mr. Altman, that I mean, the terms may be arguable, but when regulators say, as they did in this letter, conventional financial data has not been available on certain investors, and what they basically certify to is the financial strength based on their disclosures, but they say their financial disclosures are less than conventional. It seemed to me, I mean, I've read through some of the background, and I don't think this is a point worth arguing a great deal about, but it seemed to me that what the regulators are really saying is, you know, we're not sure we trust these guys. We don't know enough about them. So we want to know that we're protecting interests here, and we're expecting you to do it. And you're going to make certain representations which guarantee to us that they are going to be protected. And the representations that I believe you made, as set down by Mr. Muckenfuss, is that now and in the future. I mean, it says and in the future, there won't be a financial relationship. And also it says there won't be any financial or management dealings. I mean, I'm just asking,
Sure.
do these words not mean what they say? BCCI will have no involvement with the management and other affairs. What does that mean?
May I take that?
Certainly,
please?
sir.
That's what it says, and that's what it meant. And that's the situation that existed then, and that's the situation that existed for 9 years. If you talk about involvement in the management of having anything to do with making decisions and all, they had none, and they have not had all during the 9 years.
That's what I thought was the standard, and we agree on the standard. The question is now, is that in fact what happened over the course of those 9 years?
Well, Mr. Chairman, if I might, I think
Absolutely.
I think that you have to put this language in context. Now, my original comments you were reading from a document that I'm not familiar with.
Well, the document I was reading from is this letter.
No, sir, I thought you were reading from another one about financial information about people.
No, that's the same document. That's paragraph 4 and 5.
Oh, okay.
Same document.
It wasn't the highlighted part. The issue about the letter from the controller, I think, has to be looked at this way. It is true that the controller understood that BCCI was not going to control this operation, but the controller also had available to it information which placed this in context. The controller had the application which indicated that BCCI was going to have a continuing role, that BCCI was going to continue to provide advisory and other services to the shareholders with respect to this company, First American. The controller had available to it information that there were ties between the shareholders and BCCI. They owned stock in BCCI. They had banking relationships with BCCI. The controller attended the hearing at the Federal Reserve in 1981 when 4 of the investors appeared and testified. And at that hearing, there was testimony about the fact that BCCI was going to continue to have this investment advisory role, this role as a communications link. This kind of information was known to the controller. So it's a question of what the language should be interpreted to mean.
I agree with that. And I thought Mr. Clifford had defined it, and I thought that the language meant what it said. I mean, you see, the difficulty here, Mr. Altman, is obviously that I agree with you. All of that information was in front of the regulator.
Right.
And it was in reaction to that information that there were difficulties in proceeding forward. There was resistance, which is why that extraordinary hearing took place. I mean, it was unusual to have that.
Yes.
And it was so unusual that, in fact, Mr. Clifford appeared and you brought Mr. Adham, I believe, correct?
That's correct.
Mr. Adham and 3 others.
In order to persuade these people that this was bona fide. And part of the process of persuasion required you to say to them, there won't be any financial dealings. There won't be any crossover. There won't be any interrelationship in the affairs. And it was based on that representation, I believe, that this letter says very clearly, this is especially important in light of the overlapping ownership. Any enhanced direct or indirect affiliation or relationship would take on greater significance. And they were very specific, I think, in saying, we're going to give you a green light, but it's got to be on the terms that are set forward here. Am I wrong?
Sir, that is not entirely accurate.
Well, help me then,
If
because
I-
this is what keeps leaping out as a, I mean, they still, I believe, interpret it that way.
A couple of points. The controller understood that we were going to have continuing dealings with BCCI about this particular investment for the shareholders. We have documents that indicate that the controller was advised that we would continue to consult Mr. Abadi for ideas. Some of his ideas we might accept, some of them we might reject, but the point was the decision-making authority would repose not in BCCI, but in an American board. Now, you have said that there were to be no financial arrangements between BCCI and these shareholders. But the Federal Reserve recently testified before the House Banking Committee, and they were commenting on the existence of loans to these shareholders from BCCI that had been discovered. And both Mr. Taylor, the former director of supervision and regulation at the Federal Reserve, and Mr. Corrigan, who is president of the Federal Reserve Bank of New York, said there was no prohibition on borrowing from BCCI. There was no prohibition on borrowing from BCCI even when the stock of First American is placed as collateral. There were specific understandings as to the transaction, but I think the point that you are getting to is who was going to end up controlling the operation, and it was clearly understood that control would vest in Mr. Clifford and the American board.
The question of control is obviously a really difficult one. We're not going to resolve it here. It's a legal term, and the fact pattern is complicated as to that issue. But I guess to the average person looking at this, the issue of control in terms of a communication or a directive is very difficult to distinguish. If Mr. Abadi says to you, as Mr. Abadi, and you don't know which hat he's wearing, whether he's president of investment counselor, he says to you, you got to do this, or we want you to do this. He could be relaying to you information from investors, or he could never have talked to the investors and simply be directing you as the head of BCCI. I mean, that certainly is possible, is it not?
Let me try that, Senator. The use of the word control has caused a great deal of confusion. When the Fed first came out with statements at the beginning of this year, they talked about having found information and evidence that indicated that BCCI controlled First American. There are two kinds of control, and one time Mr. William Taylor, fortunately, described them. One kind of control is whether someone owns or has in its possession sufficient amount of stock so that under the federal rules that constitutes control. But he says there is another kind of control, and that is actual management control. Now, what we said to the authorities, what we have continued to follow meticulously, is that there would be no management control of any kind as far as First American's concerned, except the board and its chairman of First American.
Okay, well, let me come back to that after a little bit here. I want to let my colleague, Senator Brown, have a round, and I'll come back. Senator Brown.
Thank you, Mr. Chairman. Secretary Clifford, let me ask, I'm not sure I got it correctly. I thought you had mentioned that BCCI made 3 assurances to the Federal Reserve, one of which was that BCCI would not finance the purchase of First American stock.
That was the first one.
Excuse me, just for the record, that wasn't a representation by BCCI. That was a representation by the investors who were making the application for approval.
And it was confined, I might say, to that particular transaction of the tender offer. It said that the applicants shall not in any way acquire stock in First American as a part of the tender offer proceeding.
So
that was number one.
So that the financing by BCCI later on of your own stock, you feel was not a violation of this representation?
I feel that very strongly.
And that was confirmed, Senator, by recent testimony by Mr. Taylor and Mr. Corrigan. I'll read you a couple of sentences from their testimony before House Banking. Quote, "There was no commitment not to borrow from BCCI. There was no commitment not to borrow from BCCI secured by the stock of CCAH." He says the commitments required that, in order to determine a violation, that the investors borrowed money from BCCI to effect the original transaction. Mr. Corrigan went on to say, "The mere presence of loans secured by CCH stock in and of itself was not a violation of law and was not a violation of the board's 1981 agreement."
Well, the letter that the chairman talked about says it has now been represented to us that BCCI will have no involvement with the management and other affairs of Financial General, nor will BCCI be involved in the financing arrangements, if any are required regarding this proposal. You're saying that assurance, your interpretation of that is that only applies to the initial acquisition of the stock?
And that is also the interpretation of the Federal Reserve, as I've just indicated.
Fed change its position on that? I mean, I must say that I don't understand what it means. This commitment is critical both now and in the future. I mean, what does in the future mean?
Can we turn to the footnote on page 16?
Yes, sir, we have it. I think I can answer that fairly simply, Senator.
Page 16 of your testimony?
No, he's talking about, I think, the Federal Reserve application.
Federal Reserve application.
And that'll give us a good...
Well, that footnote also contains the language to the effect that BCCI is not a lender, nor will it be, with regard to the acquisition of the stock, or some language to that effect. The reason you have language relating to the future is because this letter from the controller in 1980 and the application which was filed in proceedings in 1980 and went into 1981 related to a transaction that did not take place until the spring of 1982. So what they were saying is that BCCI has not made the financing and is not financing the acquisition of the company, but it relates strictly to that specific proposal. That is our understanding. I might say the other law firms that were involved in it have so stated. That the attorney who drafted the language said that was his understanding of the language, and the Federal Reserve has now testified that that was how they interpreted the language.
Good explanation. Thank you.
I thought I would turn now to the stock arrangements and the compensation discussion. As background for us, would you tell us what it was you paid for the stock when you purchased the stock?
When we purchased the stock, Senator, we purchased it at book price, the same price that was paid by all the shareholders, and it was roughly $2,200 a share, a little more than that, I believe.
$22.16.
$22.16.
And did you borrow to finance that acquisition?
Let me start it, and if Mr. Altman has anything to add. This was in the end of 1985, as the fortunes of First American were improving so dramatically that we considered that that was an appropriate time to acquire some of the stock. Let me emphasize, Senator, this was stock in our own company. Apparently, oftentimes others have gotten that confused. But here we were, I was chairman of the board of First American, and I wanted to own some stock in my own company. We started toward the end of 1985 thinking about it, because we already knew there was going to be a rights offering sometime in the spring of 1986. Our first thought was that we would borrow the money from a French bank, BAII, are the initials, Bank Arab International Investment. And Mr. Altman had worked with a Mr. Bradshaw there back at the time of the acquisition of the old Financial General. So he knew him, started the conversation. Then we turned it over to our New York lawyers who were experts in commercial transactions of this kind. They negotiated at some period with the French bank, and they said after a while, we're never going to agree with those people. They have such a queer way of going at it, so different from our way of doing it. After having said that, I am the one who then spoke to Mr. Abadi and said, we would like to make the purchase of this stock that's left over from the rights offering, and we would like you to consider lending the money. He said, I will lend you the money if you put up all of the stock as collateral for the loan. And the reason he had that in mind was that there were occasional sales and purchases of the stock, and if he took the stock in as collateral at book value, I think he felt very comfortable because of trading that went on in the stock that he had ample security for the loan. Because so oftentimes, possibly, the trading in the stock would be above book. Wasn't guaranteed, but that was what was happening. So he said, in effect, put up all your stock, and that's sufficient collateral.
Does that mean that when you acquired the stock for book value, that you acquired it for less than its true value?
No, there's no way that one can determine that. I can only say that the bylaws provided that it shall be offered to the shareholders at book, and there might be trading, I don't remember now, there could be trading at book or less than book or more than book. We didn't know what the price was because the trading was very sporadic and did not at any time set a price.
What were the terms of the financing that you received?
The basic term, and see if Mr. Altman has something to add to this, I think that the term of the loan was possibly 18 months. We were to pay LIBOR rate, which is to some extent comparable to our prime rate, and we said that we wanted the loan to be a non-recourse loan. Now, that developed in conversations with our New York lawyers. They strongly recommended that. And the reason they recommended it was because in 1986, when we were engaging in this desire to own some stock, I was 80 then. And their recommendation was that we see if we couldn't get a non-recourse loan, it would be awfully important because my expectancy was limited, and if I should die and I left a note of that kind in my estate, it could be enormously upsetting from the standpoint of working out arrangements with IRS and so forth. So they said that in the light of the fact that you are getting the stock at book, I think you ought to insist on getting a non-recourse loan. It was to prevent difficulty, really, to a great extent because of my age.
When you say non-recourse, that means that you don't have to pay it back if you choose not to?
That means that the lender is looking to the collateral for his protection.
Well, let me try it again. That means that you have no personal liability on the loan.
I would have no personal liability on the loan because They felt that the collateral was sufficient to protect them.
Other, of course, than interest that is paid. If you pay, what it means is if you default on the loan, the lender must look to the collateral and cannot go after your other personal assets. It must look to the assets which you and the lender have agreed upon will be the assets to secure the loan.
So if the value of the stock went up, you could enjoy the value of that stock. If the value of the stock went down, you would have no liability.
Assuming we did not repay the loan, it would be a situation such as banks are facing today when a bank makes a real estate loan on a building to a developer, and the developer can't repay the loan and the value of the building has declined substantially and the bank forecloses on the building, and originally the bank had gotten an appraisal that said the building is worth $20 million and today it's worth 10, the bank takes a $10 million loss. That is the risk.
Yeah. I think
Yeah.
we've come to learn a lot about that. And, the interest rate here, you mentioned, was similar to the U.S. prime, but doesn't it normally run somewhat less than prime, than the U.S. prime?
I don't know ordinarily. I know from time to time LIBOR will run less than prime.
Isn't it usually 1% to 2% below prime? Below U.S.
I think
prime?
I would not be able to accept that as a rule. It could from time to time. I have seen instances in which LIBOR and prime were the same.
How much of the price of the stock was financed? What percent was covered?
The total cost of the stock. That first purchase of stock of mine was at $9 million and somewhat, and the loan was in the exact amount of the purchase of the stock.
So it was 100% loan,
100% loan.
non-recourse,
Non-recourse.
at a rate that appears to be below prime for the U.S.
It might have been at the time, but see, LIBOR varies. It's not a fixed rate. It fluctuates. And so I don't know how it compared at the time.
At this time, the U.S., of course, restricts loans on stock. My recollection is at this time it may have been in the neighborhood of 50% was the most you could borrow on the value of a stock, but that is for publicly traded stocks. I take it the reason that this didn't apply was because it was privately held and because it was a foreign loan? The reason you were able to borrow more than 50% of the value of the stock is because it was from an overseas source?
I don't believe those margin requirements were applicable to this transaction.
And the reason they're not applicable is because it was a foreign source or because it wasn't traded, publicly traded?
I don't recall. I think both of those reasons are applicable.
Did First American make loans to individuals secured by stocks of 100% during this period of time? Did you all loan money to anyone under terms this attractive?
I'm not aware of the terms of any specific loan. First American made thousands of loans, much of it secured by stock, some of it secured, of course, by real estate, with which we're also familiar. The terms of the loan were based upon the relationship that existed between the parties at the time. We waited for 4 years before we had proved what we could do with the property. The shareholders were exceedingly pleased. Kamal Adam was enthusiastic about the results. Abdi was pleased because he had recommended the stock to the investors, so that the negotiations for the loan were conducted under very friendly circumstances. They wanted us to own some stock. They wanted that additional bond. They wanted us to continue on as managers of the property, hopefully being as successful in the future as we had been in the past. And that's the climate within which the agreements were reached.
Did First American loan money to anyone of their thousands of loans on this favorable of terms? Was this better? Were these better terms than anybody who borrowed from your bank got?
I don't know that I can give a total answer to that. I'm sure it was better terms than the majority of the loans would be.
Do you know of any loans that were this favorable that your bank made?
I think the reason that we have some hesitation, Senator, is that neither Mr. Clifford or I were in the practice of reviewing loans. We had professional bankers and credit committees, and they handled loans, and there are thousands and thousands of loans that were made over the 10 years. I would not be aware of any loan that would be on these terms, but we are reluctant to make categorical statements when we're unsure of the complete accuracy of it, but we're not aware of it.
The amount of money involved here was, what, in the neighborhood of $15 million?
Yes, sir.
The total was, yes.
The total was
For
15.
2 loans.
My understanding was that in most banks, the board of directors and management has to sign off on large loans. Is that, did that not happen with First American?
It depends on the size of the loan, and different banks have different lending procedures and different lending authorities, but certainly you'll recall in Mr. Clifford's case, he did not sit on any of the bank boards. Mr. Clifford sat on the holding company boards, and credit decisions do not come to the holding company. I sat on some of the subsidiary bank boards, but I was not a participant in the credit committees. Some loans, such as, for example, in New York of a certain magnitude where I was a director, did come to the board. So I'm familiar with some loans, but not the general practice at all these banks.
Mr. Altman, were your loans at the same terms and conditions that Secretary Clifford's loans were at?
They were identical, but 50% of the size, same terms.
Secretary Clifford indicated that the reason, or one of the reasons for the terms of his loan was because of estate planning. Would that have applied to you as well?
Well, obviously, Mr. Clifford hopefully has a lesser expectancy than I, being 40 years older.
I serve with Strom Thurmond on the Judiciary Committee.
But I think, to clarify it, if I might, there is a factor here which is equally applicable to both of us. It is just a more pressing problem in the event of estate issues. The problem that you have here is the liquidity of the investment. You asked about what was the value at the time we bought the stock. We bought the stock at book value. We don't know what the value was if you went to sell it. It depends on whether or not you had a buyer available at the time, and there were clearly a very limited number of potential buyers. Recall that he and I were just purchasing very small percentages of the stock. And so our ability to resell that stock was something that we could not be assured of. And our counsel was very insistent that we not borrow large sums of money secured by collateral when we were not assured of the liquidity of that collateral. And therefore, they felt that if we could not get a non-recourse loan, it was preferable not to make the investment. They felt very strongly that this was to be a non-recourse loan. And when we were originally in negotiations with BAII, they took the same position, that it had to be non-recourse financing.
The lender.
Let me just interrupt for a moment. Mr. Secretary, I just noticed that your wife departed for a moment, and I know that chair is somewhat uncomfortable or something. I'd be happy to make one of these other chairs available if that's better.
That'd be great.
Would that
Thank you
maybe
very
we
much.
could have somebody just bring one of those down or something?
Much obliged to you.
The loan negotiations with BAII appears to be a loan negotiations with a bank that was in effect affiliate of BCCI and had similar shareholders. Were you aware of this at this time?
I don't believe that's accurate, Senator. At least that's not my understanding. And
You're not aware of a relationship between BAII and BCCI?
I'm aware of a relationship. I know that I believe he's the former president. I'm not sure, perhaps he's still the president of BAII. I served on the board of BCCI, but they were unaffiliated institutions. Other than this director interlock, they were unaffiliated institutions, and BAII was a consortium bank owned by a group of 30 banks or something around the world, I think. I'm not completely familiar with that, and so I don't want to suggest to you that I am, but I don't believe that they were considered corporate affiliates.
Senator, when the original deal was made, in round numbers, the investors put up $200 million, and of that, $50 million was borrowed on our part from this BAII bank. And that's why we thought of them first, because they'd been in it originally. That loan now is down to about $10 million through the years we've been paying off on it.
Were the payments called for in your promissory notes made on time?
Actually made early.
So you paid the loans off before they were due?
Well, I don't want to generalize. I should be specific. The original loan was made in the summer of 1986, and interest and principal was due, I believe, 18 months later. I would look at the documents for it to be specific. In the summer of 1987, there was a rights offering, and there was a desire on our part to participate in that rights offering, and we again sought financing from BCCI, Mr. Clifford, in the amount of approximately $2 million, and I sought approximately $1 million worth of additional financing. At that time, as a condition to getting the second loan, even though the interest on our first loan was not yet due, Mr. Clifford and I sent interest checks to BCCI for something over $1 million. So that was before the documents would require us to make payment, but it was a condition if we wanted to secure additional financing.
Well, on these original loans, they were due on January 1st, 1988, weren't they?
In January.
Yeah.
I don't remember the date. Yes, sir.
And were they paid off at that point?
No, they were, at that time, the loans provided that if they came due and we had not paid them off or sold any portion of our stock, then we could seek refinancing or ask BCCI to roll them over. And we asked BCCI to consider rolling them over. This was in December, but before we completed that arrangement, Mr. Clifford and I decided that it would be preferable to try to dispose of some portion of our holdings. And so in February, Mr. Clifford started the process to sell a portion of the stock, and the principal and all the accrued interest was then paid in March.
So that was February of '88.
Yes, that was the approximately 30 days later, whatever the exact due date was.
So at least for a period of time, these loans were in default.
Well, they were not actually in default because we had gone to the lender. We had asked the lender if they would refinance the loan or roll it over. The lender indicated a willingness to do that, but before the documents were prepared for a second loan, we started the process of disposition of the shares, which made papering that unnecessary. And when we paid the loan, even though the second loan had not been documented, we paid all interest accrued to date.
So while they might have been technically on paper in default, you had a verbal agreement to handle it.
Which was consistent, Senator, with the original understanding that they would extend it at our request.
As set forth in the documents.
The Internal Revenue Code provides for interest or interest that is charged in a below market rate fashion to be reported as income. I think they publish, the Treasury publishes the rate at which they peg that comparison monthly. It appears the interest rate that you were charged was below that rate. Did you report as income in 87 and 88 the below market rate interest that you were charged?
I do not know that it was below the rate, Senator. There was no reporting on our part. As I say, the LIBOR rate is flexible rate. The loan was made under LIBOR, and the bank set the rate. We did not set the rate. The bank set the rate. We accepted the rate that the bank set at LIBOR and paid it.
Yeah, I'm not sure that I would agree either with your assumption, Senator, or your interpretation of the code, if I might say so.
Your feeling is that the code does not require recognition as income for below market rate loans?
What I'm suggesting here is this loan transaction was one in which we negotiated with BCCI, and they advised us of the rate that would be applicable to the borrowing. I have never heard of a case where the IRS has taken the position that a loan obtained from a financial institution at a rate set by the financial institution is the kind of imputed interest that you're suggesting would apply. I think that generally is the kind of situation where a father gives a son a loan for nothing with no interest rate, and it's in effect a gift to the child of the additional amount that is the interest that is not required.
The old crown case.
But I've never heard of a case such as you're suggesting where when a bank sets an interest rate, that's regarded as imputed interest, some differential to the borrower.
Could you supply for the record, obviously if you know it off the top of your head that would be fine, but if you would be willing to supply for the record the interest rate that you paid on this amount?
Sure.
Sure.
Would you recap for us the sale of this stock? What price was it sold for?
$6,800 per share.
And was that the book value at the time?
Oh, no. No, see, there were two areas of pricing of the stock. One was book, and that is based, as you know, upon the excess of assets over liabilities of that particular company as of a particular time. That's called the book value. So that the stock that would be taken up by the shareholders when it was offered was always offered at book. We did that not only with this circumstances, but when any of the member banks gave rights offerings, it was always at book. That was a custom within First American. Now, so the book you could check on at any particular time and find out exactly what the book value was. Just to also let you know the progress of the bank, when we bought our stock in 1986, book value was $2,216. By the end of 88 or 89, it had gotten up very close to $3,000. That's how much progress the bank was making. But that book was steadily going up. But during that period, there was other trading at a different level that was not concerned with book. If an individual felt that First American was a very attractive buy, he might choose to pay whatever a willing seller and a willing buyer agreed upon.
So you were able to buy at book, but when you sold on the, wasn't an over-counter in the market, but such market as did exist, I would guess.
That's right, and that happened in a number of instances. We had heard at some time that there were sales at $4,000. On other occasions, we'd heard there were sales of the stock at $5,000. And more interesting to you, at this, there had been a substantial transaction, Senator, prior to our sale. There had been a substantial transaction at $6,100 a share. That's when the bin Mahfouz family of Saudi Arabia decided that they wished to start taking a substantial position in First American. First American was considered to be a very attractive, dynamic, coming stock. And that apparently led to those prices.
I take it book value continued to increase in '88 and '89.
Yeah, it increased each year during the 80s.
Do you recall what your gain was on this particular sale? You didn't sell all your stock, but the portion of stock that you did sell.
We sold only about 60% of it.
We have attached to our written submission, Senator, attachment I, all of the numbers for the record as to amounts received and dispersed and taxes and the rest. So you would have that available to you. But
let me just say for the record that the full text of your statement will be placed in the record with your opening comments that you made at the appropriate place in the record.
Thank you, Senator.
Thank you, Mr. Chairman.
As I read that transaction, the combined gross profit or capital gain was roughly $9.5 million?
Yes, Senator, we looked at the transaction in its entirety. We had made an investment of a certain number of dollars, and then when we sold the part of our stock, that was a certain total. And that gave us what the profit was compared to the amount that we'd spent and the amount that we received. And you put Mr. Altman's and my profit together, it came to over $9 million before taxes, and after taxes, I think my profit was about $2.7 million, and his was about $1.3 million, something like that.
Senator, I think it's also relevant to note for the record when you're examining this transaction and your questions focus on the distinction between a sale at book value and then a subsequent sale of the shares, that this was not a practice that was unique to Mr. Clifford and me in this transaction. This was a practice that First American followed generally. When First American was acquired, the the subsidiary banks that it owned had minority shareholders. And from time to time, an effort would be made to raise capital for those subsidiary banks. And a rights offering would go out for the shareholders of the subsidiary bank, just as they did here for the holding company. Now, whenever we issued stock, and this would be stock that would be issued to the public would also buy the stock in First American at book. Now, if a member of the public is a minority shareholder of, say, First American Bank of Maryland, and that bank is raising additional money, that shareholder buys the stock at book. When the shareholder goes to sell the stock, that price may be higher or lower than book. Today, most stock will trade at a substantial discount from book. Back in 1988, when we sold ours, stock generally traded at a substantial premium to book. But there are two different pricings, and that's what I'm describing is that the transaction that we followed here for the holding company was the same practice that we followed with the public in the sale of stock in our subsidiary banks.
Well, I noticed your sale in '88 being at a little over 6,800 or in that neighborhood. The report I have is that in '89, after another profitable year, the stock you were able to purchase at less than $3,000 a share, some additional stock.
That was another rights offering, and as I've just described, rights offerings were done at book. That was done by the top holding company, and that was done by our subsidiary banks with the public or the company taking its portion of it.
If I might add this there, see, we had become shareholders in 1986. So whenever there was a rights offering after that, we were entitled to whatever our share was of the rights offering at the book price, which was what all the other shareholders paid. So when we bought that stock for some little less than $3,000, every other shareholder bought it at the same price.
So it was a rights based upon your holding of the stock.
Exactly, Senator.
And that was made available proportionally to all stockholders.
Exactly.
At the time.
Can I just clarify one thing? When you talk about this sort of offering of rights and transfer, in effect, First American was taken private, correct?
It was over a period of time.
So that when you became shareholders, am I correct? I'm not sure of this. In about 1986,
Yes.
it was private.
Oh, completely.
The holding company was private,
So when you
not
talk,
the subsidiary banks.
no, I understand, not the subsidiary banks, but when you talk about the share offerings that you're now referring to, we're not really talking about a share offering to the public. We're talking about a share offering to this small family, this sort of network
Only
family.
to shareholders.
And the shareholders at that point were what, about 30 people, correct?
About half that.
Half that, 15 people. So when you say this was offered to other people, it was offered to other people, all of whom were part of this little family. The shareholders. This was Mr. Kamal Adam, this was Sheikh Zayed, etc. Correct?
There were 14 shareholders, and when there was a rights offering, it was confined to those 14 shareholders.
What confuses me a little bit is, as my colleague sort of pursues this, I was looking at a spreadsheet here for 1986. This is just for Mr. Hamoud's purchases. Now, in 1986, Mr. Hamoud purchased shares. He purchased 5,747 shares for $2,216 per share, and it was financed by a loan from BCC. In 1987, he purchased 1,216 shares. The price was $2,430 per share. He, again, loan from BCC. In 1987, he purchased 2,803 shares for $2,430, a loan from BCC financing it, and then suddenly in '88, about, 5 months later, he purchased 1,600 shares for $6,800, a loan from BCC, and then on the same day, another 3,200 shares for $6,800, financed by a loan from BCC. And then a year later, he buys 968 shares, but suddenly for $2,774 a share, a loan from BCC. A little later, on the same day, he purchases another 881 shares, price per share $2,774, a loan from BCC, and then again at subsequent transactions. You've got this range of Mr. Hamoud exclusively from loans from BCC buying shares, and this extraordinary sort of ballooning of the price of your shares, and then the balloon deflates and suddenly, boom, he's buying them back at $2,700. To the person on the outside looking in at this network of sort of 14 shareholders borrowing money from BCC, all to purchase shares in CCAH, it looks like there's something going on, and it's hard to explain it. Were there different voting powers in these different shares?
Oh, I think I have two explanations, Senator. See, you're looking at two separate types of transactions. One, when he pays something in the neighborhood of $2,300 up to $2,700 for stock, you're looking at very likely a book transaction. Sometimes when offerings were made and some of the other shareholders did not subscribe, they might let another shareholder get theirs, so he'd get theirs at book also. That would account for some of it.
Well, why?
Another answer to it is,
why would he want to pay $6,800 and incur a financial liability since he's borrowing money to do it when, a little bit later he got it so much less? I mean, why would he want to incur that liability?
well, I'll give you my answer. In 1988, when he acquired our stock, there was no rights offering that year. Now, you notice he'd been acquiring stock every year, so apparently he'd made a policy decision that he wished to be an important holder of our stock. Now, although he paid a substantially higher price that year, then the very next year, you see, there was a rights offering, and that would average down his cost. So that if you look at what Mr. Hammoud was doing, he made purchases over 4 years, and you then average out what his cost is, and it comes to something like $3,400 a share. So if he decided that he wanted to acquire a position, my own view is he went at it rather astutely. Over 4 years, he acquired a substantial amount of the stock, and his average was $3,400.
You could look at it another way, which is to say that it wasn't so astute. He made a conscious decision to go into big debt, unless he didn't have to pay the debt, but that he paid more for your stock than he paid for all the other stock that he purchased in total.
But by purchasing our stock, he gained the right in subsequent rights offerings to buy more shares at book value.
Didn't he have that right from the prior purchases?
No, sir.
Why is that?
I'm
sorry to be obtuse about it. I don't understand it, so
okay.
Tell me why.
I think Mr. Altman didn't understand. From every purchase that Hammoud made, he could always participate with reference to those purchases in the rights offering.
I was making a somewhat different point, and that is, if Mr. Hammoud makes the decision that he wishes to become an important shareholder in First American, he likes the prospects of the company and wants to become an important investor, the only way he can do it is he can pick up stock that is waived at rights offerings, but other than that, he has to buy stock from existing shareholders, and Mr. Chairman, you've acknowledged that there's very few of those. Now, when he buys stock at a premium, that gives him the opportunity in all subsequent rights offerings to get a larger pro rata allotment of stock at book. And that is, I think, the investment approach that Mr. Clifford was describing, that is that Mr. Hammoud was averaging down his costs. But let me...
How often did they make those kinds of at-premium purchases?
Well, there are any number of those trades over the years. Those are in the stock register of the company. We don't know what the prices are. Mr. Clifford has indicated some of the information we have heard, although we can't state it with certainty, but there were trades over the years.
When were you granted the power of attorney to effect that sale?
To effect which sale?
Stock transaction for Mr. Hammoud.
Senator, last night I received from the committee a power of attorney signed by Mr. Hammoud, and to the best of my recollection, I had never seen that document before. I don't know what that relates to. Let me make one other observation, if I might, on Mr. Hammoud.
The reason, if I can just follow up on it, because I want to try to understand this. And I ask these questions again, and I think you've given helpful answers, and now I understand there's a premium price and there are other sales, and I think it would be helpful to have some documentation that would show us some of the other premium sales. But the reason I ask this is that this is not dissimilar to other powers of attorney which your firm held on behalf of all the shareholders.
To the best of my recollection, that's not correct, Senator, and that's why I need a little time to study it, because I got it last night.
Did you look at the other document? There's a Kabazard, Mohammed Hussein Kabazard, who gave you power of attorney in 1983, and we have a number of other power of attorney certificates which show a 1983 date.
Do you have the number in the book?
I do. It is number 27. Just behind the Mahmoud.
Yes, sir. I see it. We got this document last night from the committee, and we've asked counsel to take a look at the files that we have. Based on a fairly quick review, we don't believe that we've ever seen this document before. Now, I have had powers of attorney from the shareholders, and that generally relates to taking action at the company, including the right to vote stock at annual meetings. But my recollection is always excluded from those powers of attorney was the right to sell stock. And therefore, when I first saw it, I thought this was another one of those powers of attorney. But this gives a authority to sell shares, and that's something that, to the best of my recollection, I'd never seen before. I don't know how to explain it. I don't know where it came from, but I don't believe it was ever in our files.
You recall, did you have a chance at all to hear or see the testimony of Mr. Rahman?
Mr.
Rahman, he's the former controller.
Yes, I saw portions of it.
He described, under oath to this committee, he described Mr. Hammoud, quote, as the most flexible of our flexible fronts for BCCI.
Well, I would say two things about that, Senator. The first is that Mr. Hammoud is one of the individuals who was not listed by the Federal Reserve as a nominee in their notice of charges. He was in the category of bona fide shareholder. Now, I can't speak for the Fed. I don't know whether that's a final position or an interim position, but we noted that he was not listed. And the second fact that I would note to you is there is a contradictory set of letters that we received. I believe we've supplied them to the committee. I know that we supplied them to the Federal Reserve when we received them, and these related to these loans from Mr. Hammoud that you indicated BCCI had extended. In the fall of 1990, we had been contacted by Mr. Hammoud's estate. Mr. Hammoud had died earlier in the year. And we had been contacted by his estate. His estate believes that the stock is stock that belonged to Mr. Hammoud and now belongs to his heirs. They certainly take the position that Mr. Hammoud was no nominee. He was a bona fide shareholder. And they had asked that the stock be transferred into the names of the heirs, and we were seeking certain documentation in that regard before the transfer could be lawfully effected. While that was underway, we were contacted by an auditing firm in London that was an auditing firm for BCCI. I had not heard of the firm before. It was called Siddiqui & Co. And they wrote us a couple of letters in which they said As to that stock which the heirs are claiming, BCCI has extended loans and we have a lien on that stock. But 3 days later,
I'm just being advised that you wanted to try to have a break. Is that accurate at some point?
No.
5 minutes?
Let's finish this.
Okay.
if we could do it when we finish this subject. But 3 days later, on November 30, 1990, we received another letter from the same firm, and it reads as follows. With reference to our letters dated November 14, 1990 and 27 November 1990, we regret to inform you that both these letters were written under some misunderstanding on our part and request you to please treat them as canceled and withdrawn. So they're in effect telling us there are no liens against these shares.
I remember that. I think you testified to that in the House.
We presented that to the Federal Reserve. We don't know what the exact truth is, so I don't know if...
Did you ever meet Mr. Hammoud?
I've met his son, but I didn't meet Mr.
Never met
Hammoud.
him?
I have never met him.
No, sir.
So this purchase took place. Well, let me kind of narrow this and tell you why the committee is concerned, and maybe you can help us out in expressing it. I mean, is it fair to say that this was a no-risk loan to you, a no-risk stock transaction?
No, you can't go that far. What we did was minimize the risk, but as Mr. Altman explained a little earlier,
What would you describe the risk as?
well, one risk is, see, BCCI always looked out for its own interests. We found that out after a while. So that when we went back to them to ask for a second loan because we had another rights offering we'd like to take advantage of, they said, well, we'll lend you the money, but pay up the interest on the first loan. We said the interest isn't due on the first loan. They said, we don't care whether it's due or not. Unless you pay the interest up on the first loan, then we'll not make you the second loan. So we paid the interest up. As you total the amount that I paid and the total that Mr. Altman paid, it came to $1,008,000. So
Didn't that in effect come out of the subsequent loan they made you?
The subsequent loan was used to purchase shares in
But
total.
the net at the bottom line was that you weren't really out of pocket in the sense. Let me tell you why I say that. There was a side agreement, correct? You had a side agreement. In addition to the stock and pledge, you had a side agreement.
We did not have a side agreement, at least I wouldn't so characterize it. We had 3 documents which constituted the loan agreements.
Well, let me ask you to turn to document 24, which is a letter which you wrote to BCCI. And in paragraph 1, it says, with regard to the note and the pledge agreement, jointly referred to herein as loan documents, notwithstanding any provision of said loan documents to the contrary, BCCI, so in other words, no matter what the loan documents say, we're going to agree to the following. Now, I consider that an agreement outside of the loan documents. It says, notwithstanding the provision, BCCI and the undersigned hereby confirm and agree as follows. So this is your agreement, notwithstanding the loan documents. Paragraph 1. Certain clients of BCCI have given BCCI a firm commitment to purchase any and all of the undersigned's CCA8 shares at such time as the undersigned wishes to sell said shares, which says to me that you entered into this with an understanding that no matter what, BCCI had an agreement with you that they'd buy the shares, so you knew you could sell the shares.
That isn't quite right, Senator.
Well, help me. What does it mean then?
Well, it's a move in that direction. But unless a price is put in there, it's meaningless.
Well, then it says, paragraph 2, BCCI shall arrange for the sale of said shares to such clients or such buyers in such manner, amount, and at such prices as BCCI and the undersigned shall mutually determine.
All right, and if there's no agreement, then it's meaningless.
Okay, let me go a little further. Paragraph 4 says, as a result of the arrangements set forth in paragraph 1, BCCI has a ready market for the CCH shares held as collateral. So they're telling you they've got a ready market to secure the repayment of the note. And it's understood and agreed that the undersigned shall not be obligated personally to repay to BCCI the loan principal or any interest accrued thereon. BCCI shall be limited solely to the undersigned's interest in the CCH shares or any proceeds thereof. So what you have, that's because they held the collateral. So they're holding the collateral, your shares, they're promising to buy them back, you don't have any interest to pay accruing, and you've got a guaranteed buyer.
That's
the
not
guarantee.
correct.
Wait a minute.
Do I misread it?
Well, until you get down to the end, we do not have a guaranteed buyer because there's no price stated in there at all. They say they think there's a ready market, they will investigate it, they will come up. If we set a price on it and nobody meets that price, I say again, the language is meaningless.
Senator,
Is that respectfully sort of a kind of, looking for the right word, I mean, is that sort of a euphemism for what you have here, really? I mean, given the relationship to BCCI, you've called it very personal. That's the way you described it at the start. There's this ongoing relationship. You've got major interests together. I mean, are they going to suddenly refuse you the opportunity to sell your shares?
Senator, I think this document may make more sense to you if you understand its origins. And if I could just take a moment with the committee and kind of walk you through that, then this may not seem so confusing to you. I refer back to the, you want me to, I refer back to the discussion that we had earlier about the advice we received from New York Council that this had to be a non-recourse loan. That was their advice to us, and obviously we were going to accept their advice. They were experts in this kind of financing. The language that you refer to in paragraph 4 was language that they drafted for the most part, and what it does is it makes this a non-recourse loan. That's all this language does. And in the BAII loan documents that were originally submitted, they put in similar language in those documents. Now, the reason this letter was created was really as a result of the evolution of the loan documents. Originally, what New York Council had prepared was what was called a put agreement. New York Council felt that in order to try to create liquidity in the stock, there was a need to have a put agreement, meaning an agreement which allowed the holder of the stock to sell it to someone, to create a market so that the stock, you wouldn't be left with an illiquid asset. And so they created a put agreement. And originally, when this loan was negotiated, they drafted these documents and they drafted a put agreement with the intention that our largest investor, Kamal Adam, who had an interest and was enthused about our becoming shareholders because it gave us an incentive to make his holdings more valuable as we build the company, he was to sign the put agreement, and that would create the liquidity. Now, this was discussed both with BAII and with BCCI. It also gave the...
Say, give it liquidity, you're really, what you're saying is marketability. It needed to
Exactly.
be marketable, I understand that.
Right, because otherwise we had no sure way of selling the stock at the time a loan becomes due. And they had the concept that it would also be advantageous to the lender, because a lender would be in the same position. The lender forecloses on the stock, and then the lender says, do I have a market to sell the stock?
Believe me, I understand what you're saying. I'm not questioning, incidentally, there's a legal structure here. I can see that. I'm not arguing that this is illegal. I'm sure, I mean, it's absolutely legal. The question is, what does it say about the relationship? I mean, we're trying to get into a kind of real person readout on this, not a legalese readout. I have no question that this is explainable in terms of marketability and put and this or that. But when you kind of bring it down to the lowest common denominator, the practical effect of it is to put into the hands of BCCI stock that is indeed marketable, but it's collateral, and it's collateral against your loan. And in legal terms, because you've borrowed money and they're holding the collateral, you are the recipient of the benefit, of the proceeds, of the sale, whatever it's going to be.
Yes.
So when the sale ultimately takes place, you suddenly get this enormous profit. Now, I'm not saying that's bad. You worked for 4 years and you deserved some remuneration. I think the question people are asking themselves, certainly the committee is saying, is, you know, wow, here's this fellow former Secretary of Defense, an extraordinary advisor and legal icon in Washington, and another extraordinarily bright, capable attorney and so forth, presidents of bank, major institution, and there's nothing in writing. There's no sort of legal agreement for their remuneration. They accept this $50,000, they go on for these years, and then suddenly, wham bang, there's this small family relationship turnaround of stock in a very short period of time with a very large amount of money. Now, you're practical people. You know that that sort of elicits a question. And I'm just trying to pose the question on behalf of people who look at this thing and say, what's going on here? That's all. Is that fair? I mean, is that a, do you see where I'm coming from on that?
Sure. There is another factor. I did not get into it before, but it could help explain it to some extent. When we reached the decision, the time had come to buy stock in 1986. At first, I did not contemplate making any loan. I could have financed it myself and intended to finance it myself. I then look at the situation in my portfolio. Market is very strong. I have very substantial gains in my portfolio. In order for me to raise the money, I have to liquidate those stocks and pay the gain. And the gain is 28% federal and 6% Maryland. So to liquidate the stocks, I have to pay a 34% tax on the gain. That seemed to be an unbusinesslike way to go at it from my standpoint. And it seemed, instead of doing that at the time, I also took into consideration the fact with which you're familiar. If I liquidate the stocks at that time in order to get the money to do the deal, I pay that capital gains tax. If I keep those stocks and die with those stocks, no capital gains tax is paid. So I'm looking at it very carefully from the standpoint of my widow and 3 daughters. So I could have financed it, but from a business standpoint, I'd be paying a tax that I otherwise would not pay when I died.
Is it fair to say, gentlemen, you got a hell of a good deal? I mean, do you at least characterize it as that? You didn't get what Steve Ross got for 1 year, but you got a pretty good deal.
Did we, under all these circumstances, get a good deal? I think we did. And I think I tried to explain that at the beginning by saying that the deal was arranged in a very friendly climate.
Now, do you also see, and I'm sure, I know, Mr. Clifford, you're too smart not to, the legitimacy of the issues raised as a consequence of that now? Do you?
Sure. We understand why it creates questions for people. We understand it very clearly. I think we would prefer we had not ever bought stock of the company in light of all the controversy about it, but it seemed so routine at the time. We were involved. We were creating an enormous value here. These people were making hundreds of millions of dollars as a result of our effort, and we thought it was appropriate, if we could acquire some stock, to participate in some of that benefit that we were creating for these investors. And Mr. Clifford talks about it was a friendly relationship. It was. when we negotiated with BCCI, it was quite friendly. They had, I think, a desire for us to acquire stock. Keep in mind, as we understood the facts, Mr. Abadi had recommended this investment to these very important clients, the people who had founded his bank and who kept hundreds of millions of dollars, indeed we hear billions of dollars, in his bank. And we are taking this investment and making it, which he once said to us, it was the best investment he ever had recommended to any of his clients. And so he wanted us to gain stock and have that incentive to continue to make this valuable. That put him in very good shape with his clients. That's what investment advisors like to do.
As you get into it, Senators, there is another factor, and it helps put it in perspective. In 1988, when we sold the stock, as we looked at the figures in that year, the amount of the investment on the part of the investors had doubled. They had put up originally $200 million. We had then called on them from time to time in rights offerings, and they had put up another $300 million. So they had made an investment of $500 million in First American. In 1988, an analysis demonstrated to us that the company was worth $1 billion, a minimum at that time. Now, interestingly enough, that was our evaluation. We discussed that at the time. They agreed over there that the value had gone from $500 million up to $1 billion. The amount that we had in mind for the unique service that we felt we rendered was minimal compared to the $500 million. Now, in order that you understand the next event that took place, in the spring of '90, we get a letter from Hugh McCall, head of NCNB. And he says, in effect, we've been investigating First American for some time, and we're interested in it, and we would like to acquire it. And he said, in order, Mr. Clifford, to show you that we're serious about it, I would say, even in this letter, I'm willing to offer you $1 billion for First American. So it merely confirmed the estimate that we'd made. When Hugh McCall said in his first offer he would pay $1 billion, I immediately translated that in my own mind that he must have about $1.3 billion, or maybe even $1.4 billion in mind. So that was the value that was offered. So that as you look at it from the standpoint of those figures, if the profit that they recognized there, that we felt and they felt we'd gotten from them with our efforts, and then the amount that would be our return on that, it came to less than 1% of what we had produced for them.
I wanted to go back for a moment, if I could, and finish the outline of the loans. As I read the documents on 8/14/70/87, there were additional loans that apparently were designed to cover both the additional stock purchase made in that period and the interest, apparently, on the previous loan.
I don't think so, Senator.
No.
Can you enlighten us as to what that was then?
There was a second loan that was made in the summer of 1987, if that's your reference, and the amount of the loan was the exact amount of the cost of the stock that we purchased to the dollar. So all the money that we borrowed, we used to buy the stock, and we placed that stock as collateral. At the same time, we were out of pocket the approximately $1 million in interest that we paid on the first loan. The interest was not funded by BCCI.
Where did the money for the interest come from? Was that, did you borrow the money for the interest payment?
Our own pockets.
Out of your own pockets?
That's right.
Well, let me suggest to you what I believe the facts suggest. Perhaps you can set me straight. I mean, as I look at this, we have stock purchases that are financed with 100% loan to value, that are totally non-recourse, and that you're not liable for the amount that's involved. The stock is held by BCCI, and the loans, interestingly enough, at least this latest loan, was written August 14th, 87, and due August 15th, 87.
Oh, that's a typographical error.
Typo in the document.
Maybe you can help us with that.
Yeah, that's
what should
right.
it have said?
I believe it was due 12 months later.
12 months
Yeah,
later.
I think it was the date was mistaken.
Yeah.
Well, what we're looking at on
conscious
the
of that at the time.
On the first loan is that it was held in default for several months. And I put it to you, if you were examining this as counsel for someone, wouldn't you basically call yourself a nominee for BCCI to
No,
receive
sir.
the stock and not hold it and not have liability?
Under no circumstances would we consider ourselves nominees for BCCI in the holding of the stock. A couple of points, Senator. As the Federal Reserve has testified, there was nothing prohibited or impermissible about our borrowing money from BCCI and our pledging the stock. And putting up the stock as collateral does not give BCCI ownership or control over that stock. I would give you an example. If you go to a bank and you're buying a house and you borrow the money, say you get 80 or 90% financing and you borrow the money, you wouldn't say that the bank owned your house. You own the house. Now, if you go into default on your loan, the bank has certain rights to foreclose and get ownership. That did not happen here. You say that the loan went into default. That is incorrect. The loan did not go into default. Prior to the time of the maturity of the first loan, we had the understanding that I have described to you, and the second loan had not even come due. At all times, we had legal ownership to that stock. At all times, we had voting rights to that stock, and we voted the shares every year at the annual meetings of the company. BCCI never had any ownership or control, and it has never been so alleged by anyone.
Well, a couple thoughts. Mr. Taylor's testimony is frankly this. The Fed received explicit commitments from the investors and their representatives that the acquisition was being made with the investors' own funds, and the BCCI would not acquire shares or finance the investors.
I think we've explained that related to the tender offer in 1982,
Right.
and Mr. Taylor has so testified.
Well, in terms of being in default, at least the documents themselves indicate that it was in default, that it was not paid when due. Is there something missing here that we're not seeing?
Yes, there is something there, but you have seen it. There's language in there that indicates that if at the due date the matter is not paid, then plans will be made to roll over the stock.
That is set forth in the same document, paragraph 3. BCCI shall assist in refinancing or shall roll over the note. It's right in the loan documents that you were just referencing.
Well, I
So the
guess
loan
that-
never went into default,
Yeah,
sir.
I think what you have to do is look at the substance of the transaction.
We agree.
And it appears to me the substance of the transaction was that you got the title to the stock without putting up a single penny of your own money and suffered no loss whatsoever if the stock dropped in price, and did not have possession. Apparently BCCI had possession of the certificates.
Only as collateral. Title did not pass.
What element is there here that puts liability on you for this stock purchase? Where where is your liability?
Well, we have said, Senator, that it was a non-recourse loan. When you have a non-recourse loan, that doesn't mean you're not liable on the loan. You are liable on the loan. We had every intention to repay the loan, and we did repay the loan, and we repaid the loan with interest. A non-recourse loan means simply that in the event you default on the loan, the lender cannot go seize your house or your other assets. You and the lender have agreed on the collateral which the lender must look to satisfy that obligation. And non-recourse lending is common. It is done all the time. I have been in other transactions in which non-recourse lending is utilized.
Well,
So
did your bank ever make a 100% to value non-recourse loan on stock?
I am not aware of any such loan.
In effect, this loan couldn't be defaulted on, I mean, in reality. I mean, the reality is you couldn't default on this loan because by the agreement, the interest
Would accrue.
correct. So there was default impossible.
Well, what it provides, Senator, is that in the event you do not repay the loan, BCCI is to assist you in refinancing the loan. And in the event there
Well, they
is,
held the stock.
or they can seize the stock and sell it.
I understand that, but I'm simply saying that, again, I'm not questioning the legality of this. I'm questioning the sort of meaning of it in the larger context, and I don't disagree with you. I think there are many non-recourse loans made, and frankly, I agree with your earlier interpretation. But I still am troubled, and I just want to say by a larger piece, and I'll come back to why and how I think that. Let me perhaps go on to a little bit of it now. You had a subsequent agreement, I guess, a purchase and sale agreement on your stock, because you continued to hold stock, correct?
Yeah.
Yes, sir.
And you made an agreement with the stock, I believe. Now, maybe I'm wrong, and this doesn't apply to that stock, but I read it as applying to the stock you hold of CCAH. This is document number 29. In document number 29, there are two agreements, one between Mr. Clifford and BCCI, and the other between Mr. Altman and BCCI. And in both of them, you say that in the event the seller owns any shares of CCAH at the time of his death, seller hereby agrees to sell and buyer hereby agrees to buy all of said CCAH shares for cash at a price of $2,310 per share, which currently represents seller's average cost per share. So in effect, your estate would be the recipient of $2,310 per share. Correct?
If you were still holding any stock.
If you
Yes,
were
sir.
holding any stock.
Right.
But you made that agreement with BCCI, and I don't understand why BCCI would be the beneficiary of CCAH shares at the time of your death. Why wouldn't CCAH shareholders have the first option to purchase?
We weren't in touch at that particular time with the other CCH shareholders. That's a group of Arabs that are in the Persian Gulf. I'm the one who came up with this thought because, again, considering about what would happen. If I die and there's stock in my estate and there's no market there, then that creates a problem again.
Well, I sure understand that.
I approached Mr. Abadi about that and said, excuse me, Mr. Naqvi by that time, and said, would you agree to take that stock off my hand? He said, yes, I would agree, would take it off your hands if you set the price at a low enough figure. So you see that it is set at book. And there are these two, we've discussed that for some time.
But at the
There's
very
book
moment
level, and then there's the trading level. So from their standpoint, they're assured they could always get book for it, and they might do a good deal better than book. I think he looked upon it as an opportunity, ultimately, of making a substantial gain.
Well, it raises the question of whose interest you're representing, the shareholders of your bank or Mr. Abadi and BCCI, who would be enriched in favor ahead of them. I mean, if the shareholders can't get a first shot at your shares and you're sort of offering them off to BCCI, it seems to me BCCI is being enriched either in the place of their nominee shareholders or instead thereof.
Senator, maybe I can assist you so that you understand this more fully. We are talking about stock, as we've described, that has an uncertain market and an uncertain value. Now, this arrangement is made very shortly after the time we sold stock at $6,800 a share. So it gives you some idea of how uncertain we thought the value of the stock was and how uncertain we thought the market or liquidity was for the shares, because in the event of death, we were prepared
Well, you've
to
just
accept.
testified a little while ago about the extraordinary growth, how it was going up every year and how the bank was worth $1 billion and how it could be sold and this was a great asset. I mean, why this uncertainty?
We believe that the value of the company, if it were to be sold, was in the neighborhood of $1 billion to $1.5 billion. But if we were to sell our portion of the stock, which was approximately 1% of the total outstandings, there may not be a buyer for it at all. And this was the point that our New York counsel was making to us. Secondly, you asked, why do we go to BCCI? A point that was made to me by New York counsel is you can't make these kinds of arrangements with Kamal Adam or one of these Arabs' shareholders, because you need someone, you need an institution, you need a place where you can go in the event you have to enforce this agreement. One of the shareholders can die, they can be unavailable. This is the kind of arrangement that should be entered into with an institution, and that's what led us to go to BCCI to effect the arrangement. Now, the result of this transaction, if it were to occur, is that there is no restriction on us selling our stock. We may end up with no stock in the event of death, or we may end up holding some shares, and given the situation today, it looks more likely than not that we would own stock of whatever value. But in the event that the shares remained in the estate, this created a market. Now, from our standpoint, we were prepared to forego any potential profit in the stock, even though we thought the company would continue to appreciate in value, because we wanted to assure liquidity, particularly in the case of Mr. Clifford. From the standpoint of BCCI, it made excellent sense because they knew these shareholders, they had access to them, and they felt they had this ready market for the stock. So if they bought the stock from us at $2,300, they felt they could turn it around at a profit. That was the expectation in this arrangement. And we didn't have that same access or same assurance.
Now, let me just ask, counsel, I'm just concerned about the time question on the break. We're going to break for lunch before too long, and I know you wanted to have a solid interval there, which we're delighted to provide. Do you want to continue for another, say, 15, 20 minutes and then break, or?
At your convenience, Senator.
Is that all right? Okay.
I would like to, so that we know we're making progress.
Thank you very much. We are making progress, and I think we're getting somewhere here. Mr. Altman, if I can just direct you, this is something I know that came up in the House a little bit. It still has left a few questions, and I want to ask them.
Okay.
Document number 30.
30?
30. This is the letter somewhat argued about now that you were sent by Mr. Ryback from the Federal Reserve, in which he said to you an issue was raised on whether any of the financing, this is December 13th, 1989.
Yes, sir.
At this time in 1989, the Fed expresses a specific concern about whether any of the financing of the equity investment I was referring back now to the letter that we referred to earlier. We sort of began with the original standard of operating here.
Right.
And the original standard of operating was the notion that there would not be a mix of the financing, business, management, et cetera. This letter now says that it recites that. It reasserts that principle and says in 1989, according to the Fed, it was indicated at the time, referring back to the original takeover, that the individual investors had substantial funds and only a modest portion of the total investments would be financed. Further, any personal borrowing by the investors would come from financial institutions unaffiliated with BCCI. I know you've been through this somewhat. I just want to make sure people understand what I'm asking. Next paragraph says, in order to clarify the situation, it would be helpful if you would provide information on any loans extended to the original or subsequent investors, either directly or indirectly, by BCCI or any of its affiliated organizations. The information should include all loans extended to the investors, regardless of purpose, whether they're secured or not, in what manner, et cetera. Now, I know you explained to the House saying that you didn't think that that applied to you because your loan had been paid off. Is that accurate?
Yes, sir.
In the letter you got back from Mr. Altman, to you from Mr. Naqvi, as a consequence of, I think, your forwarding this or forwarding information about it, Naqvi says to you, he says, I can't provide you with confidential information about our customers' financial arrangements, which begins a process of evasion, to you, incidentally, not by you, but to you. He then says, we can confirm that none of the shareholders involved in acquisition had any personal loans. That's just not true, and we've learned that. Of course, no stock of CCAH or Financial General was placed as collateral for these loans. We know that that's a lie on its face. It's a lie, incidentally, to you, by him. And then it says, you should be aware. But he starts out his letter to you saying, I'm writing in response to your inquiry concerning whether there are any loans to any of the shareholders in connection with the acquisition. But the letter from Mr. Ryback to you, and he has indicated to us that he was not looking just for the acquisition, and in fact his letter is very clear. It said, will you provide us with information on any loans original or subsequent investors? And my question is why you would have let go by the notion that there were in fact subsequent investors, namely you, who had taken a loan from BCCI for the purchase of stock. Whether it was paid off or not, that was not the question.
That was the question, Senator. Let me see if I can help you with your understanding of it.
Well, how do you, first of all, just tell me, how do
Sure.
you read that into the original question? I mean, into his original letter. Does his original letter say original or subsequent investors?
Yes, sir. The way you read the original letter is correct, but there were subsequent communications, oral and written, which will confirm what I'm trying to explain to you.
Now, was there any written communication from the Fed that altered that? Did the Fed alter that?
There was written communication given to the Fed which altered that.
That's the memorandum that you wrote.
And more than that, there was other documents that were provided.
Have you provided those to us?
I believe, yes, Senator, I believe we have.
Do you know which ones they are, Mr. Bennett? I'm not familiar with them.
I think Mr. Altman will be going through them now.
Okay, fine. That's terrific.
Mr. Ryback in December had submitted to me a letter that is rather broadly worded, and you have very accurately read it into the record. When I received the letter, I spoke to Mr. Ryback. Indeed, I spoke to him more than once. And Mr. Ryback explained to me what it is he was seeking by way of information. I might note that the first paragraph of Mr. Ryback's letter, I believe, is the matter relating to the tender offer. Then he goes on in his second paragraph and deals with the subject of any loans made then or subsequently. Now, when we received this letter and spoke to Mr. Ryback, I pursued the matter in two ways. I pursued the matter with BCCI directly, and I pursued the matter with our shareholders, and then I provided the Federal Reserve at various times with the information that we had learned. Mr. Naqvi's letter that you have referenced indicates that BCCI did not finance the original acquisition. I don't have access to the documents. I accept what you say, that that is an incorrect statement, but that was the representation that was made. He goes on to say in that letter that you should be aware that in the years following the acquisition, some of the persons who are on the list of shareholders of CCAH have from time to time borrowed from BCCI. He indicates there are subsequent borrowings. He doesn't detail them because he won't give us that information for the reasons he describes in his letter. Now, during this period, 1989 and into 1990, we started to receive reports that were disquieting reports about the issue which you are now investigating. I think I have testified before the House that we heard about this conversation of Mr. Awan, the taped conversation of Mr. Awan in which he makes reference to nominee arrangements. And we had looked into that matter. We had gotten that transcript. We had spoken with Mr. Awan's counsel. We had had an interview with Mr. Awan himself. I didn't personally, but others did and reported to me. The Fed has also looked into that, and Mr. Awan has said that he didn't have any information. It was a corporate rumor that he had heard. And we had pursued it in other ways as well. We had pursued it with the shareholders directly in some instances, and we had pursued it with the most senior management of BCCI. I pursued it, other attorneys pursued it, and we pursued it aggressively. We received information back that we thought at the time was credible. In this time period, the issue of lending arrangements arose, and matter came up about what BCCI's practices were. And actually, before this letter, it's my recollection that an invitation was extended to Mr. Ryback to go and meet with the senior management of BCCI so that he could ask any questions directly that he might have. And Mr. Ryback indicated he didn't think that was indicated, and that invitation was declined. When we received this letter, we then pursued it, and we heard these reports that there were large loans out there, that the loans were secured by stock. And we reported that back to the Federal Reserve. We did not necessarily think that the lending was impermissible for the reasons that Mr. Corrigan and Mr. Taylor have stated. It was not impermissible to borrow, even borrowing secured by the stock. But we gave the Federal Reserve the information we had obtained. There is a document which has been provided to the committee, and it is marked Note to Files, BCCI, dated January 9, 1990. I make reference to this document because you need not simply accept...
I'm sorry, is that the May 8th, 1990?
No, sir, it's an earlier one.
January 9th.
You need not accept merely my representation about these conversations with Mr. Ryback. This is a note that Mr. Ryback himself wrote, that is my understanding, to his files. And let me read to you the pertinent parts. Robert Altman called in response to my letter concerning loans from BCCI to shareholders of Financial General. Mr. Altman related that he talked to officials in BCCI Luxembourg, and they are in the process of pulling together the information we need. He states that BCCI told him that none of the shareholders of Financial General directly financed the acquisition with loans from BCCI. However, in subsequent years, some of the shareholders borrowed substantial funds from BCCI because of a slowdown of their business interests in the Middle East, and the fact that Financial General was not paying dividends, some of the borrowings may be supported by a pledge of Financial General stock. He was not aware of the payment history on these loans. And I also talk about a potential merger. So I told Mr. Ryback within a couple of weeks of receiving his letter by his own document that we had heard there were large loans out there, but we didn't have the information about it. Now, Mr. Ryback, as I say, explained to me the focus of his inquiry. And the focus of his inquiry was twofold. Primarily, he was interested in ensuring that the original representations that had been made were accurate. That is, the representation that BCCI was not financing the purchase of shares in the tender offer. And that representation had been made. It was made in that footnote that we have described in the application, and he wanted to be assured that that had been observed. That was his primary focus. He had a secondary interest, however, and the further interest was that he wanted to know if there are any current loans outstanding to these shareholders, personal loans. And the reason that had relevance is because of the issue of controlling influence under the federal statutes, whether a lending institution can get a controlling influence by reason of large outstanding loans. So he originally writes a letter that is very broadly worded in December. I report back to him what I have heard about there being large loans, but about there not being any financing of the original tender offer. That is the representation that was made. And I then proceed to send letters to the various shareholders. Now, I say that I indicated that Mr. Ryback was not interested in certain kinds of information, even though his original letter would seem to call for it. Mr. Ryback wanted these two specific kinds of information, and I had also indicated to him that to comply literally with this letter, I am told would be burdensome to get every loan ever made to any investor by BCCI, and that's why he focused his inquiry as to the specific information that he needed for his purposes. On March 9, 1990, I write a letter to shareholders, individual letters, and I state the following. We've been asked by the staff of the Board of Governors of the Federal Reserve about representations made by the investors who acquired First American. At the time, the board was advised that the acquisition of the company would be primarily from personal funds and would not be financed by BCCI. BCCI has recently written a letter confirming the accuracy of these representations to the board. I say this to the shareholders. They're all on notice as to what's happening. Then I go on. The board staff has requested current information on loans extended to First American investors by BCCI, including stock pledge to secure any such borrowings. And I say the board's not interested in certain things. And then I go on at the conclusion of the letter, and as I say, this was provided to your staff. It says, if you have no personal loans at present from BCCI relating to First American, you may simply write us a short letter to that effect. I make very clear by the language, if you have no personal loans at present from BCCI, that is,
I'm just trying to find it here.
sure. It is a letter dated March 9.
Letter you wrote, right?
It is a letter I wrote to shareholders and signed. And the language I'm reading, well, it's the entire letter. The language I was just reading is the concluding paragraph.
Would you provide us? I don't think we have that, or I don't have it. Do you know where that appears, Mr. Bennett?
Would you like my copy? I can.
That's all right. If I can just get a copy. You've read most of it, and I've been listening.
I believe it was provided to you, but in any event, it makes clear this was our understanding in real time. This was our understanding of what they were asking, and we in turn were saying to the shareholders, do you have any outstanding loans? not did you ever have loans that have been repaid. The Fed wants to know, we say to the shareholders, about the original financing, and they want to know about any loans that are outstanding. Now, interestingly,
You didn't sense from the Fed, Mr. Altman, I guess these things are always subject to interpretation, obviously, and I'm not trying to force you to interpret something differently than you did. But I find it sort of, I guess, strange that they bring up the issue so boldly in the front of the letter about the original concern and the way, and that original concern sort of ran throughout their regulatory effort. Now, if you say to me, Mr. Ryback had a different interpretation in conversations, we accept that. And I do know that Mr. Ryback has no memory of altering his original request.
well, Senator, if I might, the letter that I just read to you was a letter that was given to the Federal Reserve. So it is, I talk to Mr. Ryback, I tell him what I've heard. I am told there are no loans relating to the original financing. I am told there are large loans out there that we don't know what the information is, we just understand there to be large loans. And I'm told by him what we're interested in is current outstandings. Is there any, what is the situation regarding current outstandings? And I confirm that in writing in this letter that I'm describing, and then we give this letter to the Fed to show the Fed the information we are seeking to elicit. Now, I'm sure if Mr. Ryback says he doesn't recall it, I accept that, but this letter will be in the files of the Fed, which makes very clear the inquiry we were making in response to the Federal Reserve's
I have no question but that was your interpretation, and that's the way you went back to them. The question in my mind partly is, where the Fed went in terms of their original inquiry, and because the original inquiry, I think, means one thing, that you had those conversations or that you, in fact, made those representations is on its face absolutely clear and accepted. The only question is, was it full disclosure? You knew at the time, I mean, would it have been that difficult to list the people who had BCCI loans outstanding for the purchase of CCAH shares?
I didn't have that information, Senator. I knew that Mr. Clifford and I had had loans which had been repaid a couple of years earlier, but that wasn't responsive to his inquiry. We get a letter, we talk to him, what is it that you want? He tells us, and we try to get him that information, and I confirm in writing that that's what we're trying to get for you. Now, you also have a memorandum dated May 8th, 1990, of a meeting we had with the Federal Reserve.
I do, I have that. Who wrote that memorandum?
The memorandum was drafted by one of my partners, Mr. Lesher. I also reviewed it, and on the last page, Mr. Tuttle's name appears, so I assume he also reviewed it. We were all three at the meeting, and this was a memo to the file to summarize and to record what was said at that meeting. And
now, just to put this in a context, this May 8, 1990 memo was written, you cite the Regardes article in the Wall Street Journal, and this is just about at the time, was it not, that Price Waterhouse had had a meeting with Masih Rahman in London and had made public to him and others the report that they had at that time. I think it was about a month earlier or so, regarding the regarding all the inaccuracies and problems that were appearing at that point within BCCI.
that was not made available to us. In fact, Price Waterhouse did not, when there was an inquiry made of them at that time, they didn't even mention that report.
Okay.
So we were unaware of this Price Waterhouse April 1990 report.
Okay. Let me just inquire.
Sure.
Do you have more you want to ask now?
Just a couple quick ones, and I know we're going to
Okay.
come back this afternoon. To put some sort of cap on this, did you disclose to the Federal Reserve the financing you'd received from BCCI?
Well, we disclosed it subsequently. We didn't disclose it in response to Mr. Ryback's letter as it was non-responsive.
It was non-responsive to this letter or non-responsive to what you had discussed with him after this letter?
When I received this letter, I talked to Mr. Ryback to understand the information that he wanted us to collect, and he explained that to me. And he explained that he was primarily interested in ensuring that BCCI did not, in fact, finance the original tender offer in 1982. He says, I have a secondary interest. I don't want a lot of volume of information. I don't need a lot of detail. The second thing that I need is if you can get information on any loans that are today outstanding. So it was not a question of withholding information that we could have provided to him. It was, this is not what he's interested in. And I understood the regulatory objective that led him to make the inquiry. So we say to him, we are told there are no loans, there was no financing of the original tender offer. And we get him confirmation of that, whether accurately or inaccurately. And we report it to him orally, and he makes a memo to the file about it. We tell him we hear there are large loans out there, but we don't have any of the details. All we can tell you is we hear they are there. And he says, fine. The confirmation that he is seeking only current loans, and therefore our earlier financing was not relevant, is indicated by the letter I've just described to you, which was given to the Fed, that says in response to your letter, this is the information we would ask the shareholder to provide.
Did you feel comfortable in not disclosing?
It seemed immaterial to me. I didn't think anything of it. It was a loan that was made. It was a loan that was repaid. I didn't attach any significance to it. We had reported the fact that we had purchased stock every year to the Fed. They were aware of it.
Well, given the fact, let me just ask about that.
Sure.
Again, given the fact, and I apologize to my colleague, but given the fact that you had these articles which you referenced in the memo yourself, and there was then circulating a certain amount of innuendo regarding the bank, and there was a significant amount of sort of, hey, First American's owned by BCCI and so forth. Is it not fair to say that had you disclosed that you had significant loans outstanding, that would have simply excited that process and interest significantly?
Senator, 2 points. One, we didn't have loans outstanding. The loans were repaid a couple of years earlier. So it had nothing to do with this particular allegation insofar as we were concerned. And secondly, as I think my memorandum indicates, Mr. Ryback subsequently did not even seek us to pursue information about current outstandings. We tell him we understand there are loans that were made subsequent to the original acquisition. And as I indicate in my the memorandum dated May 8th, I read to you a sentence from that meeting. This is what he is telling us, and we're trying to be responsive. We weren't trying to hide the fact that we had loans. It just didn't seem to be of any particular moment. Mr. Ryback stated that I'm quoting, that his limited concern was only to inquire as to any BCCI financing of the original acquisition in view of information supplied him by foreign supervisory authorities. We agreed to get permission from Mr. Nakvi to release the BCCI letter, the letter where he says there was no lending, so that they could check that. And then I write Mr. Ryback a letter on June 11th, and I say to Mr. Ryback, as a follow-up to our meeting, this is simply to confirm that Mr. Nakvi, quote, has advised he has no objection if the Federal Reserve wishes to show his January 31, 1990 letter addressed to me to other supervisory authorities. Then I go on. Again, if you wish us in the future to seek any additional information concerning any financial arrangement between First American's shareholders and BCCI, please let us know. So at that point, even the current information as to current outstandings, they had indicated they didn't care if we pursued it, and that inquiry, as far as the Federal Reserve was concerned, lapsed. Now, 2 points. The first, from the Federal Reserve and from our standpoint,
Apologize.
from the standpoint of both the Federal Reserve and ourselves, frankly, we didn't think there was anything to these allegations about nominee arrangements, etc. So the fact that the Federal Reserve did not seem particularly concerned or excitable about reports that there were large outstandings didn't strike me as peculiar. We did personally continue to pursue the issue. We had talks with the shareholders and talks with BCCI management, and in the fall of 1990, when we got this report about Mr. Hammoud and the possibility, the dispute as to whether he had large loans outstandings relating to this, because it related to this earlier inquiry, we provided that to the Fed when the information came to our attention. I'm talking now about the Hammoud letters we were earlier discussing this morning. So whenever we got this information, we submitted it to the Federal Reserve so that they would know what we knew.
Appreciate it. Senator Brown, do you have any more? Or?
Mr. Chairman, I just wanted to enter in the record some figures that I think relate to our previous conversation. The loan that was taken out in July of 86, or 1986, was at the LIBOR rate. And the LIBOR rate at that time was 6.75. 6 3/4. It does appear that that is the rate of interest that was paid the following year. That particular rate, the LIBOR rate, the 6 3/4% interest, was 1 1/4 to 1 3/4% below prime in this country at the time, and at the point it was the note was due was about 1.5% below prime. So it was significantly below U.S. prime, not comparable with it, but significantly below U.S. prime at the time. Also, in checking with the CRS, the tax law division, they indicate the applicable federal rate was below or was above the rate, the 6 3/4 rates. Thus, the Internal Revenue Code provisions, the feeling is, would apply. In effect, the loan rate, the rate on the loan was below the applicable federal rate. And therefore, I think significantly raises a question with regard to tax liability in this area.
We would disagree with that conclusion, Senator. If I might also note for the committee on the subject we were just discussing about Mr. Ryback, there was a letter that I also wrote to Mr. Ryback that I did not earlier reference. It's dated February 5, 1990, and in that letter, I state, quote, "My understanding that your primary interest is the current state of borrowings from BCCI from many of the First American investors." So this was a letter I wrote to Mr. Ryback to that effect. Was that,
Gentlemen,
did you hear me, Mr. Chairman?
Yes. Let me just say that I think we've made a lot, we've covered a significant amount of territory. There are some areas that we definitely have to go into this afternoon. I appreciate your patience, and what we will do is, according to our agreement, I think we'll